Good morning, everyone, and welcome to the DC Court of Appeals. We have 3 cases on this morning's calendar. I should say we are happy to have with us this morning Judge Cheryl Long from across the street at Superior Court. Senior Judge Long is sitting by designation with us today, and of course, my colleague, Judge Deal. The first case on the calendar is number 23 CT 002. Gibram William Armstead versus District of Columbia. Whenever you're ready, counsel.
May it please the court, if I may reserve 3 minutes for rebuttal. Thank you. I have the honor of representing Mr. Armstead. We filed 2 claims in our briefs. The first claim is a Fifth Amendment claim for suppression of evidence that was denied after a finding that Miranda rights were violated and that the questions were asked while the defendant was in custody. Focus of my argument today will mostly be on the Second Amendment claim. That is the second claim that we've listed. However, we rest on our briefs on the first claim, but I would be happy to answer any questions the court may have at this time regarding that before I move on.
Thank you. I think we're ready to hear about Second Amendment.
Yes, Your Honor, as far as our second claim regarding the Second Amendment right of Mr. Armstead to be able to travel, the rightful ability to be able to travel between state lines where he can legally possess firearms is our second claim. The first issue that I'd like to address is the preservation of the issue.
Can I just pause, not to take you off your point, but you frame, I just want to understand what your Second Amendment argument is. And I think you just articulated, which is if you could legally possess it in Maryland and you could legally possess it in Virginia, then the district statutes and how it controls, how he has to transport it between 2 places where he can legally possess it are unconstitutional. And my question for you is, that argument rests on a predicate, the predicate facts being that he could legally possess it in Maryland, Virginia. We don't have facts. We don't have a factual finding about that. The district says clearly that's not true because he couldn't have possessed this in Maryland by virtue of having a Utah license, and he didn't have a license in Maryland itself. So this argument can't get off the ground. You haven't established the predicate facts for it. What's your reaction to that?
Your Honor, I believe that there are predicate facts that the court could use that was established in the record. The record does indicate that Mr. Armstead did have a license to carry in the state of Utah. It was his testimony in the defendant's case in chief that he was permitted to be able to carry in Maryland and in Virginia. He's taken some licensing and state requirements, and that it was his belief, and there was nothing in the record that firmly the government did not present any evidence into the record that contested his ability to be able to carry in Utah. That license was produced in the record. And then also Mr. Armstead's understanding and licensing courses were also introduced into the record as far as his safety courses that he took in Maryland. And there was nothing that the government presented outside of mere argument that he was not able to possess in Maryland or Virginia.
Yeah, I'm not sure what he presented to say that Utah license gives me a right to carry it in Maryland. It strikes me as at least a quasi-legal question. And the district now cites us to laws saying that's wrong. And there's no response. Why couldn't we say it is uncontested that Utah license, as a matter of law, would not have, contrary to your client's beliefs, would not have given him a right to carry it in Maryland, so the predicate facts necessary for your Second Amendment argument, we don't have them. And we certainly don't have a finding about that from the trial court.
Correct, Your Honor. However, Your Honor, I don't think that should bar us from being able to argue the merit of the argument. Now, if it could be remanded for further factual findings by the court on that. However, the underlying issue is still whether the statute itself is unconstitutional as it's written for the ability of an individual, an unduly burdensome of an individual that does have a license in another state and his ability to be able to carry it from one state to another where he can otherwise legally do so. The record is, Mr. Armstead's understanding of in the record is that he is legally able to have that weapon in Maryland. He is legally able to carry that to
I
Virginia.
don't understand why you say that. I mean, that might be his understanding. The district says he's wrong. Here's the laws that show that he's wrong. They cite us the Maryland laws that say Utah license would not give him a right to carry in Maryland, and I don't have a response to that. What's your law that says the district is wrong about that?
Your Honor, I don't think the court needs to go into the analysis of what the other state's law is. I think that the government did not present that in its case, that he was not able to carry it. There was nothing to contest that testimony of Mr. Armstead. So I think on the back end, we are looking at whether he is able to or not present day. However,
They made the legal argument before. The trial court didn't address it. The trial court, but the district, as I recall, argued that he doesn't have a right to carry this in Maryland toward the end, when this argument first came up, which was after the close of evidence. That's when the district said, like, we contest the predicate that he was actually allowed to have this in Maryland. They now come to us and cite us the law that says he wasn't. And I don't have any contrary law in front of me. So I don't know if you need an opportunity for supplemental briefing, but you had a chance to file a reply. I don't have it. And I don't have any, like, point me to what, why doesn't the argument not get off the ground? Because as a matter of law, there's no predicate to say that he had a right to carry this gun in Maryland.
I understand, Your Honor, and we do rest on the record as far as the testimony, and unfortunately, we do not have any additional information regarding whether he had the right to carry that specific gun in the state of Maryland, but I would not mind filing a supplemental brief to that specific question.
I mean, just to be clear, we'll ask, I suppose, in an order. I won't do that on the fly here at oral argument, but I will say personally, to get into a meaty Second Amendment question on a factual predicate that we do not have findings on, and strikes me as, so far as the law that we have in front of us, strikes me as most likely wrong, would seem to run contrary to the doctrine of constitutional avoidance, and just be an imprudent thing to do. Because I mean, this was, correct me if I'm wrong, this was what we might colloquially call a ghost gun?
Yes, the trial record shows that the trial attorney ended up making that argument at the MJOA stage after the close of all the evidence. And so this was not a written motion or a motion that was briefed on at the trial level.
Counsel, I want to follow up on the issue of the gun in question being a ghost gun. Why do we need to get into an analysis of whether the appellant had a right to carry it, given the type of gun it was? He went to trial and decided to testify in a case based on the gun that was seized, not a gun that he perhaps wishes had been seized. We have to confront what the record actually shows. So why is it that a ghost gun is something that really causes us to have to get into this fine analysis?
Your Honor, I think that the analysis of whether it's a ghost gun or not, there is some testimony in the record regarding the ghost gun. However, but there is not any clear indicator that this specific ghost gun, based on the testimony that was presented by the officers, was illegal in other states. The only testimony we have in the record is that an officer's testimony that this is a ghost gun. This is what he believes to be a ghost gun. This is what's typically is a ghost gun if it doesn't have a serial number on it. And that's the testimony in there. But there is no expert testimony as to whether this gun is indeed a ghost gun. And there's no evidence in the record that goes to show that this gun was illegal in other states. It's just the officer's analysis of the gun in the District of Columbia. And so I don't think that that fact that it was a ghost gun should still bar the court from ruling whether the transportation of a gun from one state to another, where an individual believes does have the right to carry, should be barred, because the intent was just to pass through. So I don't think the analysis of it being a ghost gun should bar a decision in this case.
Counsel, you may get, you've had some of this already and you may get more, but because you didn't file a reply brief, there are several things we don't have your thoughts on. And one of them, in addition to some of what's been discussed already, is the government's standing argument in response to the Second Amendment challenge to the transportation regs. Why isn't the government correct that your client does not have standing to level that constitutional challenge.
Your Honor, the government's challenge as far as the standing is based on the fact that the trial court raised the level based on a statute that he is not charged with. Is that, if I could
Yes,
clarify
yes.
the question? Yes. So in order to evaluate transportation, the standalone clause of carrying can't be looked at without looking at the other statutes, meaning one thing falls from the other. So in order to look at the carrying concealed and the ability of an out-of-state person that is not registered in the district, the court must look at the transportation statute of individuals living out of the district to interpret if the person is in violation. So while there was not a specific charge of that, and there was not a motion filed in advance of that, it's not an attack on the indictment. The government did put forward in the indictment a charge under DC law that was an accurate charge in the statement of offense. However, in order to evaluate whether Mr. Armstead was guilty of that, one must also look at the underlying transportation statute in conjunction with it. So I believe that the argument entails both statutes in order to be able to get us there. I don't think it was
Do
waived.
you have any case law supporting your position?
No, Your Honor. However, the court did, in this case, look at the argument. They looked at the transportation statute when making their ruling. And at the trial level, the government did not object to the argument being made at the MJOA stage. So while the government may be objecting in the Court of Appeals brief that it was waived, at the trial level, the trial attorney failed to object on the government's behalf.
Oh, I think we're mixing up two different types of arguments, right? Maybe I'm wrong, but I think the government has sort of two distinct arguments. One is the one that I think Judge Beckwith was starting with, which is you weren't convicted under the transportation statute. And I understand your answers to that. It sounds now that you're kind of pivoting to the government's other argument is, and whatever objection you made too late because you didn't bring it up until the close of evidence and you should have raised it pre-trial. So is that the argument that we're on now?
Yes, there's
We're not-
two waiver arguments that the government is making. The first waiver argument is that you cannot look at the transportation, you cannot look at a carrying concealed permit without looking at the other statute, regardless of whether it's filed on the indictment or not. So one must look at that statute to be able to understand the defense that Mr. Armstead had in this case.
That's the standing argument, not a waiver argument.
Yes,
right?
but the waiver, Your Honor, as far as it was not filed prior to the MJOA stage, is that the question?
I think that might be Judge Dean.
Well, I was just, I thought you were moving to that. So I wanted to preface that we're now in a different argument and so that I
Although
understand.
as I understood that, sorry,
No, please.
how are you? As I understood that, the preservation argument really focused more on the remaining arguments about the more straightforward constitutional attack on the UF and the UA statutes, not the affirmative defense.
Well, the statute as written of him being able to carry a weapon, we're not looking at whether an individual in the district can carry a weapon. This is simply as it relates to individuals out of state. So if individuals out of state are carrying it from one place to another, we must look at the transportation statute when looking at that. So the waiver that the government is indicating is that, well, they didn't specifically ask that it was unconstitutional because it was not charged, that was not filed. I think that it doesn't matter that it was not charged. I think that in order for us to be able to evaluate the statute as a whole, we have to look at the other statute because that is what makes it the unconstitutionality and the overly burdensome requirement of an individual passing through. So there is no way you can look at just one statute on its face without looking at the other one. So I don't think that it was waived just simply because the trial attorney did not indicate that on the record.
And then on the Rule 12 argument, I think what you were saying is we raised the argument. They didn't object to it being untimely at the time. And in fact, you have a trial court saying this argument's preserved. So if they want to come make a Rule 12 complaint to us now, too late. If anything, they're the ones who are in violation of sort of the general waiver principles that they didn't make that argument below.
Correct. Well, there's a twofold argument on that, Your Honor. One of them is that Rule 12 does indicate that certain motions are untimely if not filed. However, what the government is relying on in that situation is 12B. Court's indulgence.
Yeah, 12B5, I think.
12B5. And Your Honor, as I said, we're not indicating that the indictment as written, the statement of offense is incorrect. So there was not a facial challenge to the way it was written itself. The challenge is actually to the constitutionality of the transportation statute. So we believe that it doesn't fall under 12B. However, even if the court found that it did fall under that and that the trial attorney was required to write a written motion in advance with the motion schedule, the court considered several factors. One, that it was raised at a point. The court did not object to the untimely argument, even though the court did say it was a convoluted argument at one point. They did not object to it being raised. They did not indicate that they needed a briefing schedule. They did not indicate why was this not filed. In fact, Bruin, I believe, came out a month prior to the trial date, which was a very large, complex case, which is assumed that neither the government or the trial attorney objected to that because it was raised within a month, and that was when the trial date was set. So that may potentially would have been the earliest time, even if something was filed, the trial attorney could have filed something, would be right around trial. So the judge did hear it. And we would argue that it's a waiver upon waiver because the government didn't object to needing additional time to make an argument either at that time. And so now on the backhand, they're saying that it was waived when none of the parties indicated at that time that it was waived. And we do not have a record of good cause, which the court could have come to, but we can say that the court implicitly found good cause due to the fact that it was within a month, they had no objections to it, and if they needed additional information, they would have indicated that on the record. However, Your Honor, because the government did not object at that time, we do not have a record of good cause from the court. And so due to the untimely objection by the government, I don't think that the government should be able to argue waiver now on the back end. Your Honor, we wanted to focus on the government's requirement, and I understand that we've kind of gone, is there any more questions on waiver?
No, I don't think
Thank
so.
you. Your Honor, I believe that is my time.
Go ahead and make the argument you're about to make. But
Your Honor, the government in
time.
its brief has not submitted any kind of historical analog that would require the district to have these undue burdensomes on transportation. The biggest thing is that in this case, Mr. Armstead did have it disassembled. It was in different areas of the vehicle. It was not able to be functional in the manner that he had it. The one thing that it was not in a locked box. I understand that the government has the ability to be able to have some restrictions on Second Amendment. However, some of the restrictions are above and beyond necessary and not rooted in any kind of analog. And so the thing that we would be showing is that there's the statute as written, especially the requirement that an individual has to go from one area to another for recreational purposes, and the fact that it needs to be in a locked compartment when it's already disassembled is above and beyond the requirements that is under the Second Amendment constitutional. Thank you.
Thank you, and we will give you a couple minutes for rebuttal.
Morning, and may it please the court. Ryan Leach for the District of Columbia. I'd like to start, Judge Deal, with the question that you asked of my colleague, because I think it goes to one of the critical failings of the claim in this case, is that there is no showing on the predicate facts of legality of his possession of the firearm in Maryland or in Virginia. We cited the law as we understood it The law that we found about Maryland's reciprocity requirements, essentially there are none. Virginia has certain types of limited reciprocity requirements. What we found, Mr. Armstead has never made any attempt at trial or on appeal to cite law to provide any, he provided factual evidence related to his handgun license or some sort of other certificate that he had in Maryland. We noted that in a footnote. It's never mentioned on appeal. There's no law cited. There was no reply brief filed. The fact that their Second Amendment claim.
Can I just ask about what the record evidence is on that? As I recall, and so I just want you to tell me if you think I'm wrong. There's some record evidence that he completed a firearm safety course in Maryland prior to this stop in DC. I think there's then also a license to carry in Maryland a couple of weeks after that was issued after he was stopped in DC. Is that right?
That is my understanding.
Okay.
We noted that in a footnote. It's never mentioned on appeal. It's never, the basis for their argument on appeal is that it was the Utah fire license that got them across the finish line on both points. That is, as far as our research reveals, that is inaccurate as a matter of law. I also think it's largely legally irrelevant, particularly in a case like this where Judge Long, where you were mentioning earlier that we're dealing with an unserialized firearm, which our submission is they haven't carried their burden to show that that is an arm in common use under the Second Amendment. But I also do want to circle back to the point that has been raised about the procedural posture of the case, the way that this issue was raised. Our position is that the Rule 12 sets a bright line rule. There needs to be a pretrial motion for constitutional challenges to offense creating statutes unless there is good cause shown. Here, there's never been any attempt.
Yeah, tell me where you get that from Rule 12. Or am I right that you're 12b-5?
Yes, Your Honor.
Why do you think, so I mean, Rule 12 mentions certain constitutional rights that you need to assert pre-trial, including in 12a-3, you have to raise a violation of the constitutional right to a speedy trial. But 12b-5 doesn't say you need to raise a constitutional challenge to the legitimacy of a statute before trial. What it says is you need to raise a failure to state an offense claim before trial. Now, this is not a failure to state an offense argument. You've stated an offense. It's on the law is on the books. And that law is unconstitutional. Why do you think that's a 12b-5 challenge?
That is how the rule in every case that I have found has interpreted it in the federal system and in this court. I don't have a citation right at my fingertips for that. But
I mean, the only case I think you guys cite for that, I think it's Federo. I think it was a 2018 opinion of this court, a precedential one. Was Federo, and that was a genuine, this is not a law. This is the law that was not passed by the legislature, so it's a violation of separation of powers under, Article 1. That fits within 12b-5 quite handily. It failed to state an offense. This is not actually a criminal offense they've charged me with. This does not seem to fit. So, I mean, if you have something you can point me to that you think is persuasive, why a constitutional challenge to a statute is akin and should be interpreted to fit within 12b-5's failure to state an offense. I'm happy to read it, but I don't know why the court would say that.
Two responses, Your Honor, if I might. First point is this argument's never been raised by the other side. They could have made this argument in a reply brief and they did not. The other point I want to make is that I don't have a citation at my fingertips. I'd be happy to file a supplemental letter. Every Court of Appeals decision that I came across that related to this rule, this is how it's been interpreted. I believe the DC District Court has interpreted it this way as well. This is simply the standard course for these types of issues.
Do you want to just articulate what you think the basis for that is? I mean, it's one thing if everybody else is doing this, and that's fine. I mean, but that's some point in favor of us doing likewise. I just don't know why I would read 12b-5's failure to state an offense to mean you have stated an offense and it's unconstitutional for you to enforce it. Those strike me as two very different things.
I think there's an implicit idea that there's failure to state an offense means failure to state a valid or constitutionally valid offense. That has to be what it means, I think. And the reason I don't think that's all that different from how 12b-6 might work in a civil context. I mean, failure to state a claim oftentimes is predicated on a constitutional defect in some part of a case. So I don't think that's necessarily out of touch with how this type of language is typically interpreted in both the civil and criminal context. But I'd be happy to provide the court with supplemental authority on that if the court wishes.
Well, I guess my other question is, well, what do you do with the fact that the district didn't raise a challenge to when Mr. Armstead raised this in the trial court? In fact, you have what looks to me to be a trial court ruling. He says, you've preserved this, let's move on. So why wouldn't we just take that as, okay, there's no fight about preservation. The trial court says it's preserved, nobody disputes it. Why would we sort of more closely scrutinize, like she said, like opposing counsel said, they could have put on evidence of good cause, possibly, timing was tough. Had anybody raised a challenge to when they raised their challenge, to get a little meta about it. But it wasn't raised, and so we should just proceed,
Yeah.
Sorry. What's your reaction to that?
Our first order submission is the Rule 12 is a bright line rule. The second point we would make is that even if you assume it was there was some waiver of the Rule 12 issue, the argument still wasn't adequately presented below. And the reason I say that is because not just because the trial court ruled on it, but it's important to look at exactly what the trial court ruled on. It ruled on a version of the argument that could be extracted from one component of what they argued, but it's not clear that that was the argument they were raising below.
Well,
It
this is
wasn't clear.
something that I want to ask you about that I was confused about in your brief, or I wasn't confused until I saw your 28K letter yesterday, but your brief reads like there's this challenge to the transportation requirements. I read your brief to not be pressing a preservation argument, just pressing a standing argument on that. And then this broader attack on the UFUA statutes under Bruin, you were attacking clearly as unpreserved. Is that what you're talking about? Now, your 28K letter was confusing to me because I think it said something about there being no preserved Second Amendment constitutional challenge in Mr. Armstead's brief, when I had thought that you were kind of conceding this narrow part was preserved and you were just going after it on standing grounds.
Our position is that whatever argument, I would be candid with the court, we had a difficult time understanding exactly what argument was being raised. I think the court shares some of those confusions based on the colloquy so far. We did our best to try and understand what had been argued. Our position was that whatever was raised below and whatever is being raised now was not adequately presented to the trial court to provide the trial judge a fair opportunity to rule on it. I acknowledge the trial judge discussed some of the issues about the transportation statute, but it's important to compare that ruling to what they're arguing now. What they're arguing now, they're trying to invoke Bruin, but there's no analysis of the offense creating statutes in the trial court's ruling. There's no analysis of Bruin because I don't think the judge was fairly apprised of it. And there's no analysis of some of the additional questions now that are being raised about whether or not it's a facial claim against the transportation statute or not. I understood my friend at one point to say they were raising a facial challenge to some law as written, but then sort of disavowed that and said it depends on how it's applied. So I think all of these types of confusions, I don't think the trial judge was given a fair opportunity. Even though the trial judge did discuss some of the merits, it's not clear whether the trial judge understood what argument was being made. And this is exactly why a rule like Rule 12 exists, so that we don't have to engage in this sort of analysis of a cold record to attempt to divine what the trial judge might have been thinking or what the
Well,
trial
the trial
judge
judge
understood.
appeared to think that he or he was, had enough opportunity or treated it as preserved. It would seem unusual for us to say the trial court was wrong about that on the grounds that you're saying now.
Yeah, I would agree. I don't know that I would agree. There are cases where this court has looked at a decision, said that a trial judge ruled on it, and then said on appeal, it's still not preserved. The Baxter case involved that. It was an unpreserved Batson challenge. Nesbitt appears to involve a similar type of scenario where it was a situation where, yes, the trial judge ruled on it or appears to have ruled on it, and this court nevertheless said, hey, we're sorry, it's unreviewable. It's either plain error or it's entirely barred. So I don't think it's that unusual for this court to affirm on the alternate ground, or at the very least, say this is something that we don't think the trial judge had a fair opportunity to rule on it, even if he thought the issue had been presented to him. Because the question being presented now, I'm still not quite sure what their argument is, but it doesn't appear to align with exactly what they argued below.
And what did the government say at the time of the discussion at trial about preservation?
We were asked one question about the merits and then the court ruled. So I don't know that we had a fair opportunity to fully raise this. I think it's important. One thing that might be lost in the record on appeal is just how sort of out of the blue the Bruin issues came up. It was mentioned one time during Mr. Armstead's direct examination, and then it was never mentioned again
The
until.
government is very good at saying, that's not adequate or this is too late. The government definitely knows how to say that. It isn't the absence of that kind of argument telling.
I think it would be telling as to the Rule 12 component of our argument. When it comes to the adequacy of the actual preservation of the argument, I don't think that it was incumbent upon us to say at the time, we don't think that there are these other arguments that aren't being preserved right now. I don't think that's practical. I think it's a question of, you look at what's been argued below. If it's just a skeletal assertion and a bare citation of one case, my friend noted that Bruin was this large, complex case. If we accept that as true, it's hard to imagine the trial judge, we can't just assume the trial judge knew every detail of Bruin or understood exactly why Bruin will open the door to challenging the district's
Now, do you think-
firearm laws.
Do you think that your argument now about the challenge to the affirmative defense transportation, requirements issue is different from how it was in your brief? Was I misunderstanding you as not, as basically treating that as preserved or being, saying nothing about its preservation?
I think even if the court assumes that that issue was preserved, I would acknowledge that is, I think, the basis for the trial judge's ruling. So even if you accept that that was preserved, our position is that it still is not something properly before the court, because this is just one part of an affirmative defense that they admittedly can't satisfy. Typically, defendants don't have standing to challenge a law that doesn't apply to them, whether it's a defense or a separate prohibition.
But isn't it, it's so intertwined, like it feels like it would affect the right to present a defense almost if you can't. This transportation statute is something only the district can charge it, right? So the district could have control over whether it ever gets challenged. And yet you're saying because he wasn't charged under this particular statute, he has no standing to complain.
I don't think it necessarily is a situation where no one would ever have standing, although I would bracket for the moment that just because no one would have standing doesn't mean someone must have standing.
Yeah.
But I think more to the point, there are ways in theory in another case, a defendant could, I think, bring a Second Amendment type of challenge to this defense. I think the way it would work is if they could satisfy they had a plausible argument for satisfying every criteria of the defense, but then they said, this additional requirement for me to take some, whatever the step is, or there's a question about how broad the statutory term is. And if it's construed more broadly, it encompasses my conduct, but if it's construed more narrowly, it doesn't. That was sort of the situation in Hargrove with a different defense. And the person could raise a constitutional avoidance argument under the Second Amendment and sort of say, you've got to construe this more narrowly, or else you're going to be violating the Second Amendment. But that's not what Mr. Armstead's case is. And I think it's important to recognize that there are multiple bases for why he can't invoke this defense. So even if this is why the transportation statute doesn't affect the outcome in this case. The only part of the transportation statute that he is challenging is brief. There's one sentence on it, and it refers to having the gun unloaded and then having it in the trunk. That's not the only requirement of the statute. The statute also has criteria related to the purpose for which you are traveling to the district. He can't satisfy that. So even if the court were to reach a determination, we think would be incorrect, that there's something burdensome about the criteria and the manner of carry regulations. There's still an additional reason why it wouldn't change the fact that he's still in violation of the unregistered firearm law.
Yeah, but what's my reaction to that is, yeah, he's saying you can't do any of it. If I have a right to carry a gun in self-defense in Maryland and Virginia, the district can't preclude me from traveling through it because I'm not going between point A and point B for purposes of recreation. They also can't preclude me from disassembling the firearm and keeping it in the truck, where when I also have a right to carry it for self-defense while passing through the district. So it's all, like, none of it works. So why would they need to go piecemeal, and why would we need to have a claimant in front of us who says, well, I satisfy these requirements and I'm only want to do this one targeted challenge? I kind of understand him to be saying none of this is good.
I think the first argument that Your Honor posited is more in line with what's being argued here, which is that I should have a right to carry this through the district however I want, whenever I want. That argument, that assertion rests on the Second Amendment. It's a novel, wrong, atextual Second Amendment theory, but it has nothing to do with the transportation regulation. If that argument's right, the statute, the unregistered firearm statute is unlawful as applied to him, regardless of the transportation regulation. But that argument's wrong, and it doesn't make a difference as to whether or not there's a separate affirmative defense provided by a statute. There are other affirmative defenses provided in the statute as well that he also doesn't satisfy. But that doesn't mean that this court is now open the door to considering whether every affirmative defense is too narrow, simply because it doesn't apply to one individual's intentional decision to carry his firearm, an unserialized firearm at that, through the district without valid registration, without following proper protocols.
Do you understand yourself to be making an argument on the merits about the transportation statute? That's another thing I wasn't clear on, because it seems mostly to be about standing, except for maybe in one footnote.
Again, Your Honor, I think we struggled to understand exactly what was being argued. We do have arguments that we could make about the transportation statute. We noted it in a footnote in our brief, admittedly in a footnote. There were historically traveler defenses that existed when concealed carry prohibitions began to arise in the early 19th century. Many jurisdictions allowed people traveling through the jurisdiction to carry as long as the firearm was not on their person and was in their baggage. The Texas case we cited was that fact pattern, and the person there was convicted because he had the firearm in his hand and not carried in his baggage. So these laws, these transportation requirements, the district's law, as well as I would note a materially identical federal law, 18 U.S.C. 926A, capital A. These are, I think, historically justified traditional manner of carry regulations that Mr. Armstead now claims on appeal in one sentence is an undue burden, but there's no further analysis of why that is or how it affects the Second
I
Amendment.
mean, is this the part of your brief where you say these laws are mere legislative policy choices? Isn't that, I was confused about that, because that seems like something that Brune says is the very kind of thing we should be looking at.
It is not the very thing.
It
is, I think.
in figuring out history and tradition and all of that.
Well, I apologize for any confusion on that. I'll try and articulate the point we were trying to
Okay,
make.
thank
which
you.
was-
I'm
was-
easily confused. so.
No, it's,
Uh.
the fault is mine. I think the point we were trying to make was that not every jurisdiction had a traveler's defense to concealed carry prohibitions. The fact that not every jurisdiction had one, though, I think just shows that they were not compelled by the Second Amendment, which means that the district's law currently, which is a manner of carry regulation of the same historical lineage, is also not compelled by the Second Amendment to be any broader than it currently is. That was the point we were trying to make, Your Honor. I would acknowledge that if the court wishes for supplemental briefing on that issue, we'd be happy to provide it. We did our best to understand what argument was being made. We weren't sure that one sentence in the opening brief on page 9 was enough to preserve this argument on appeal. If just to direct the court's attention, the second question presented in their brief only cites the unregistered firearm law and the ammunition law. It mentions something about transportation, but it doesn't cite that statute. So it's not clear. I take my friend now to have conceded that those laws are valid on their face, and there's now some sort of claim against the transportation law, but that's not quite the argument they made and focused on in their brief.
I thought that was the heading of the second argument in their brief. So I mean, let me just take you to it and let's see if you think I'm wrong.
No, it is in the heading. It is in the
All right.
heading. Yes.
Right, I mean, that's, this is our top line argument, that it's all about the transportation, and we need to be able to carry these things through the district without these onerous restrictions if we're going from one place where we can carry illegally to another. I mean, that's what I took their argument to be. I mean, I take your point it is, you know, it's a page-long argument. They don't really, you know, on a weighty constitutional question, I myself would have extreme reticence about addressing something that is not more fully fleshed out. I'm not sure it's not enough for preservation for appellate purposes, but, you know, I take your point, but you don't think sort of top lining it like that is good enough for, you know, teeing up the question?
I think it's a closer question, Your Honor, in fairness. The fact that the question presented doesn't mention the statute and that the topic sentence of their argument at bottom paragraph of page 8, where it appears, only mentions the it finally mentions the offenses of conviction, which were not ruled upon by the trial court in this case. And so it's difficult to determine what exactly has been preserved. I think in a case like that, particularly when they don't file a reply brief, defending their position below, explaining what they're arguing on appeal, explaining how it was preserved. I think that should give the court every reason to at most apply plain error review to this claim. We don't see that there's any basis for deeming it to have been preserved for purposes of a de novo review of what could potentially be a massive constitutional challenge that would implicate not only the district's firearm laws and transportation laws, but a federal statute materially identical that also regulates the transportation of firearms through different jurisdictions for lawful purposes.
But do you concede plain error review would be appropriate?
That was a second argument that we made. Our primary argument was we think the court could apply a waiver total unreviewability principle to the Second Amendment arguments, but even in the alternative, at most, we think they should get plain error review. And the fact that, again, they didn't argue plain error in the opening brief, they didn't file a reply brief to take up that challenge, is a substantial reason for this court to, you know, at the very least, not give much weight to the arguments that they're now trying to make and trying to salvage that oral argument without the opportunity for us to have a
What
formative
is the
position.
government's position on the concurrence in Chu that you cite a couple times in a but see Chu, you know? Do you know what I'm talking
Oh,
about?
yes,
Yeah.
yes. Yes, Your Honor. So we understand Judge Easterly's very thoughtful concurrence on this issue. I would acknowledge that the consequences of not complying with Rule 12 in this jurisdiction are currently open. I think as Judge Easterly very thoughtfully explained, in the federal circuit, there's a 6-3 split in favor of our position of total unreviewability, even under the amended rule. But I would note that the only open question with Rule 12 really is the consequence of failing to comply. There's no dispute that there is a bright line rule that you have to make the motion pretrial or show good cause. And if you don't do that, the question is just, is it totally unreviewable or is it plain error? But there's no question you get to de novo review. There's no question that it's untimely. And the fact that there's never been a showing of good cause below or even on appeal, again, no reply brief addressing it. I understand my friend to sort of argue that, well, we didn't show there was no good cause, but even assuming there's someone has to show it on appeal, I don't think it's the government in this case. If the court has no further questions, we would ask that the judgments of conviction be affirmed. Thank you.
Thank you very much. Ms. Patel, we will give you 3 minutes on rebuttal.
Your Honor, the first thing that I'd like to touch on is the government's waiver argument regarding the constitutionality that it falls under 12B. I want to point out to the court that under that, it's specifically actually under the first, it's lists out specific times where 12B applies. And in fact, one of them is if the constitutionality of speedy trial, and in there it does not indicate the constitutionality of a statute or something that the individual may indicate. So I would submit that if Rule 12 was meant to encompass all constitutional challenges, then that would have been specifically written because the legislature goes on to list very specific things where 12B applies. Second, I understand that the government argued that it is our burden to show good cause. And while that may be correct, if the record reflected that there was neither parties that asked for good cause to be shown. I know the government in its response indicated that the trial attorney, the prosecutor did not have ample opportunity to be able to state on the record. However, there's nothing in the record that he had anything more to say. He did not ask the court to perfect the record. He did not ask the court to consider any other arguments. In fact, when the court said that they are ready to rule, both parties permitted the court to rule and did not indicate that they needed more time to brief, that they would like to brief on the issue. It is very common practice that if an attorney did want to brief the issue, the court would have allowed the attorneys to brief that specific issue before ruling. This was a bench trial, it was not a jury trial, so the court could have taken a pause to be able to let both parties brief if either parties requested a brief on that, or if the court felt that a brief was necessary. And so we would argue that 12B does not apply in this case, and by the court ruling on the case and neither party's objecting, it was a waiver, and that we do not need to go into the analysis of good cause, or an alternative, the court can find that the court found good cause by moving ahead with the motion and ruling on it. Second, I know that the government focused heavily on the legality of the gun, and originally, when I went back to the record to look and just declare, there was testimony by Mr. Armstead and by the officer that Mr. Armstead had actually tried to register the firearm. He had a certain date in Maryland to be able to register this firearm. And the officer in the case basically said that it seemed like Mr. Armstead was trying to comply with Maryland laws and was trying to come up to date with some of these things. And so there was nothing in there that Mr. Armstead was incorrect about his interpretations and what he could and couldn't do in Maryland. I understand the law that the government is arguing on the back end that it is illegal to have a ghost gun, but on July, when he was stopped and the record evidence shows that Mr. Armstead was legally allowed.
What keeps on tripping me up is you're talking about a question of law. Could he legally have this in Maryland? So to say, well, the record evidence didn't say otherwise, you usually don't need witness testimony on what the law says. You know, the law is the law. We can look. We do that all the time. We tend not to have witness testimony about the meaning of laws. In fact, usually that's precluded because it offers a legal conclusion. I mean, you keep talking about, well, the testimony doesn't show that it was illegal, but the law might. And I still haven't heard any reason to think that he could have possessed this legally in Maryland.
I understand, Your Honor. I believe that's when the court must look at the intent, and the intent of Mr. Armstead was that he owned a legally possessed firearm. He had no reason to believe that it was not illegal. He believed himself that this was proper and that this
Well,
is.
I mean, that's usually not a defense to anything.
I
So
mean-
I didn't mean to break the law. Usually doesn't work. Why would that matter?
Believe that the government has shown that he was not permitted to have this gun I believe that they presented some law that says that ghost guns can be not permitted in Maryland. However, they haven't shown that that gun specifically that Mr. Armstead.
Yeah, but no, they've cited Maryland laws saying you cannot, a Utah license would not give you a right to carry this gun in Maryland.
Well, Your Honor, there's also was evidence that Mr. Armstead did have some certificates, as the court mentioned, and some safeties. And so he was under the understanding that he was permitted to have that gun on that date in question.
Yeah, but if he was wrong, who cares?
I understand, Your Honor. I believe that the court does not need to make a finding on the legality of that gun in the other state to still reach a conclusion on the constitutionality of the statute. And I did want to focus just a little bit on the clauses in the statute that makes it very broad, including the requirement that individual must participate in any lawful recreational firearm related activity in the district or on his way to and from an activity, and that precludes the individual's right to be able to defend himself if he was carrying it from one state to another, passing through the district. Your Honor, if there's no more questions, I submit.
Thank you very much.
Thank you.
The case will be submitted. Second case on this morning's calendar is Allison McCracken et al. Versus Raed Jarar, and hopefully someone will correct me if I'm mispronouncing that. Number 24 CV 62. Mr. Jarar, is it? I understand you're appearing pro se this morning, just so you may already understand this or have done your homework, but how this works is appellant's counsel has 15 minutes to argue and he may save some time for rebuttal. We may go over the 15 minutes as you've just seen happen in the first argument, but we try to stick to 15 minutes. He will have some time for rebuttal and then you will have 15 minutes. You do not get rebuttal. It will go back to Mr. Lipper after that. Okay. And we will ask you questions and you can respond to them. Thank you.
Thank you, Judge Beckwith, and may it please the court. My name is Greg Lipper. I represent the appellants, Allison McCracken and Gabriella Smith. I'd like to reserve 4 minutes for rebuttal. The plaintiff, Mr. Girar, in this case, a few months after the events at issue, wrote an admission which was attached to his amended complaint, in which he said, quote, "I am deeply sorry about the physical abuse that I inflicted on you. Meanwhile, in April and May, I look at my hands and think about how I pushed, slapped, choked, and hit you. There is no excuse for what I did. I'm ashamed of my actions, and I am sincerely sorry for all the pain that I have caused you. Not only am I remorseful for the physical violence, but I also realize the verbal violence was horrendous. So on and so on. I hold myself 100% accountable, and I am the only one to blame for crossing the line, breaching our values, and violating your trust." And it goes on. In his amended complaint, he says only about that written confession that he was, quote, intimidated and that he wrote it to protect his children. And even in his declaration, he doesn't actually say specifically that what he wrote in the admission was false. He says only that he was told to omit that it happened, quote, during sex, quote, during a mutual sexual encounter, and similar formulations.
Can I interrupt you and say, the judge in this case found that there was not a prima facie case made, correct?
Correct.
And are you jumping to the question of, likelihood of success, or can you place the argument, the point you're making about these facts into the legal argument?
Yes. So the actually, the next sentence out of my mouth was actually going to be no problem at all. It was I read an extended excerpt. Given the allegations, given his written confession, and given his less than robust attempt to disavow his written confession, no reasonable fact finder could conclude that the alleged statements were false, and therefore Mr. Girar has failed to demonstrate a likelihood of success on the merits as the act requires him to.
If the Anti-SLAPP Act applies.
If the Anti-SLAPP
Which I think Judge Beckwith might have been prompting you to, the ruling below is it doesn't. So I mean, we'd consider all that evidence if we were on something like a summary judgment standard, which would require application of the Anti-SLAPP Act. The trial court says this is not speech in furtherance of a right of public advocacy. It's primarily targeted toward a private interest, a private dispute between parties. Many of the statements between private parties, some public, maybe with a sprinkling of some public interesty things in there. But generally, this is a private dispute, so I'm not going to apply the Anti-SLAPP Act, was the trial court's reasoning. And if that's right, then we don't get into all the record evidence, which looks much more like a summary judgment review. So I guess should we start there?
I'm happy to start.
Please.
Happy to start there, Your Honor. So as we argued in our brief, that trial court's threshold ruling was incorrect for a couple of reasons. I think the first thing is that just as a description of the statements at issue, I think the trial court was incorrect. And so, for instance, the December 2022 Facebook post, Ms. McCracken alluded.
Can I, I'm sorry, I'm going to bump you even to a more predicate question.
Sure.
Is the right way to do this? It's my inclination. Is that you, and I think you're about to do this, to go statement by statement. When we're determining whether or not the communications at issue are primarily, I think this is where the real fight in this case lies. Are they primarily private concerns? Are they primarily targeted at issues of public interest? Do we look at the body of statements Do you take them one by one? Do you take them one by one, but as a whole, and you can't just pick and choose sentences?
So I think, well, I think the third, your last formulation is probably the one I would agree with most, and I'll explain.
Oh, good. So do I.
Let me explain why. So a couple of points here. I mean, so as a general matter, and the court said this in the American Studies Association case, that generally speaking, you're looking at these things kind of claim by claim, and that includes defamation claim by defamation claim. However, here, the complaint itself alleges that all of the statements were part of a coordinated, quote, campaign, in which all of these statements were made by the defendants to, you know, quote, destroy his reputation within the nonprofit community in which he works. And given his allegation that it was a coordinated campaign, that we need to understand the statements collectively. Some of, you know, and obviously some of them, I would say on their face are more obviously covered than others. So the Facebook post, the December 2022 Facebook post, it's a statement on social media. Ms. McCracken in that post actually doesn't mention Mr. Giroir by name. She alludes to the fact that she had been a victim of domestic violence, but the substance of the post is, number one, a fundraiser for an organization that provide services to survivors of domestic violence. And number two, an offer to, you know, encouraging other people in similar situations to come forward and offering to help them. So that was very much, in that case, sort of alludes to her own situation, but very quickly uses that as a springboard to discuss domestic violence issues more generally and to help other people who are victims. So that's the first point. Likewise, the Twitter posts, which I believe are February 2023, certainly Ms. McCracken is talking about her own experience, but she is linking that explicitly to a broader issue, which is that, you know, physical abusers should not be tolerated as leaders of progressive organizations. I think one important thing to understand here is all of the people involved, all of the defendants in this case, and Mr. Giroir are human rights advocates, and at the time were, you know, all were human rights advocates, you know, in a community of organizations dealing with human rights in the Middle East, and so, you know, Ms. McCracken is coming from that community. You know, people she interacts with are in that community, and this has been a debate. The debate about, you know, in particular, and even specifically when we cite some articles about this, you know, going back several years, the role of sort of people who, you know, hold seemingly progressive views, work in progressive organizations, but have their own allegations, and how should those organizations respond, and how should the community respond?
Can I interrupt you there?
Yes.
I understand what you're saying. There's sort of a mixture, and that the Saudi something case
Yes.
specifically says that that's okay, and, you know, we're going to loosely characterize what we think of as, you know, I forget the language, in the public interest or
Advocacy on an issue of
advocacy
public
on an
concern.
issue of
Yeah.
public concern. And I also agree with you that close it is different, you know, very different from your case, and not a good case for your opponent, because it's just, that seems so clearly more directed to someone's personal issues and the source of the defamation claim. But the judge here, I guess, was applying a standard that I've seen that about it, whether it's directed primarily at a private interest. And, you know, the judge is seeing, I think correctly, I think you concede, issues that are purely private, texts that are, you know, just going to friends or small groups of people. If that's in there, and if we're really using a word as kind of, you know, manipulable maybe, or nebulous as primary, how do we get to where you are, that it crosses the line into being primarily about matters of public concern?
Well, so this is where I think it probably does make sense to say So the messages I just discussed, so the Facebook post and Twitter post, and I would say, perhaps a Wikipedia post as well. Those are, I think you can look at sort of on their face, because I would say, for instance, the Facebook post, you would have to go out of you would have to read subtext that isn't there in the Facebook post to say this is primarily devoted to a personal matter when she doesn't even mention Mr. Gerard's name and is trying to raise money for an organization. Likewise, in the Twitter post, she explicitly links what happened to her to the broader issue. And then I think you can look at some of the other more some of the other messages that were, where the audience was more limited. And you can say, first of all, that textually, so if you look at DC code, so it's, the definition section, which is 5501, section 1, subsection B, does not have the requirement of a place open to the public or a public forum. So section 1A little 2 does, but section 1B, which is the provision we're relying on primarily, talks about either petitioning the government or communicating views to members of the public. So there's no threshold audience size or public forum requirement. And I think that makes practical sense if you think about, and again, all of these people are sort of professional organizers. If you think about how a campaign for any issue operates, it's always going to involve a combination of public statements and more person-to-person statements. If I decided, we need a dog park in my neighborhood, I'm sure I'll go on blast and talk about how there isn't enough space for our dogs. But if I have neighbors who are dog owners, I'd probably go to them as like, hey, don't you think we need a dog park? And if I thought, the dog park was being opposed by some corrupt official, I would say to them, our dogs would have space in the park if not for that official. It would be almost malpractice to not have those person-to-person conversations in an advocacy campaign. So I think some of the statements just on their face are directed publicly, and then others I think you can look at as part of that broader campaign. And again, you don't need to guess about that. The amended complaint itself alleges that this is all part of a single campaign, even going so far as to—
I kind of want to understand what you think the issue of public interest is. I just want you to kind of frame it for me, because I can see two very different ways to frame it. One way of framing it is, advocating for victims of domestic violence to come forward, and, putting a stop to it. That seems like clearly an issue of public interest. Another way of framing it that I feel like you get into sometimes, and I'm just not sure it's what you're embracing, so let me know if it is, well, tearing Mr. Gerard down personally and professionally is also an issue of public interest, because we should not want domestic abusers to be in positions of power. Is that, if that's what she's doing, like take out the parts about donating to an organization. Let's just say Ms. McCracken, this is largely what Mr. Gerard alleges, is engaged in a personal campaign to, stop Mr. Gerard from being able to have gainful employment. She doesn't believe he belongs in the space that he's in, and that he's a danger to the community as a professional. Is that an issue of public interest, or would you say that's an issue of primarily private concern?
So I think it's an issue of public interest, but I think I would characterize the campaign a little differently than you are, given what's alleged. The first thing is that, Mr. Gerard is, by his own allegations, a prominent, human rights advocate, and holds a leadership, position in human rights advocacy, and he describes this in more detail in his declaration. And so his presence and leadership role in that community is very much an issue of public concern, in the same way that the sort of membership at, who's speaking at a conference was an issue of public concern in the Saudi American case. There's another case we didn't go to in detail, but Mr. Gerard cited in his brief, the Fells versus SEIU case. We have a similar analysis, albeit with I would say probably a higher ranking leader. One other point just on Mr. Gerard, and this is in the record and in our brief, Mr. Gerard himself had previously before Ms. McCracken ever opened her mouth in this case, Mr. Gerard previously was the subject of national media coverage because he had been fired by Amnesty International after an investigation showed that he acted inappropriately, sexually inappropriately around a female colleague, and then turned around, claimed he was being discriminated against, and filed a discrimination and defamation lawsuit. There was a Bloomberg, news article that was sort of presenting this nationally. So Mr. Gerard specifically, his leadership in the human rights community has itself already been the subject of sort of national media coverage. The case was resolved by a confidential settlement. And so now we're getting more information that goes to sort of, should Mr. Gerard, a prominent human rights advocate, be in this position of leadership in the human rights community, advocating, to be clear, on behalf of people to be free from, unwanted violence, for instance. And the final point I want to make is simply, like, as I said, given the allegations, we believe this is sort of, fairly described as a common uniform. Before I go further, I see my time has expired. Should I continue? That the allegations are this is a sort of a common campaign, and so you can understand it as such. If you disagree with that and you think and you want to look at the statements, one by one, if some of those statements would be, would establish the prima facie case, which the court has said is not an onerous burden, then at a minimum, those statements would be protected, even if some of the others wouldn't be.
I would think that would be, why isn't that your main argument? If you really think it's true the way you were describing the Facebook, you would at least have that. If you did it statement by statement, you seem to be indicating the Facebook statement, which doesn't even mention Mr. Gerard, seems to be more defensible as falling within the statute. I'm curious why the way you are arguing it, Judge Deal's third way or whatever.
Yes.
Are you is that your take because that's just how you read the case law, or?
Well, I think a little of both. I think there are, I do agree, and I forget, it was a couple of questions ago. I do agree that there's sort of two purposes here, which are sort of somewhat related, but somewhat distinct, which is number one, sort of, providing support to domestic violence organizations and to victims of domestic violence. I think that is clearly part of it. And the other part of it is making sure that sort of, in this case, unrepentant, domestic abusers are not in leadership positions in human rights organizations. I think I will say, obviously, that those purposes are more manifest in some of the statements than others. And so I would say at a minimum, some of the statements are protected, but I think given the allegations that it is a overall campaign, and given the fact that it makes sense that in a broader campaign, you would both have mass communications as well as statements to smaller audiences of members of the community, that there's no reason to disregard that allegation, which is that it is part of an overall campaign. So
Go ahead.
I have one more, but you can go first.
Okay, mine might be slightly off topic, so you go.
I think mine might be too, but I'll go ahead so we don't drag this out.
Okay.
you're the judges, so it's inherently on topic.
I would like to just I have one question on sort of the second half of it.
Yes.
Let's say I agree with you that at least some of these statements fit within the Anti-SLAPP Act. So we get to the second stage of likelihood of success on the merits, roughly a summary judgment standard, as I understand it, of whether or not a reasonable jury could rule for Mr. Gerard. And I take, your primary argument is, look, we have this confession and nobody could doubt that he has been abusive in this relationship in light of it. But then there's more targeted statements of him having broken her jaw and broken her neck, which so far as I can tell, a reasonable jury could think that's false based on what the evidence is. I don't think there's evidence in the record saying that that's true. And a reasonable jury could think that that's also not substantially true. I mean, I think your argument in your brief is there's substantial truth to it if he was an abuser. And that seems like quite a big leap to me. And I wonder if you want to defend it, that if somebody admits to having been abusive in a relationship, it is fair game and free from defamation law to say things like they broke my neck and they broke my jaw.
I don't know that I would, so I'm certainly happy to defend our substantial truth argument. I don't know that our argument is as broad as you just formulated it, Judge Deal, in the following respects. If you look at the overall message of this campaign, and again, you can look at how the overall message is described in the amended complaint and in Mr. Giroir's declaration. The overall message, as he understands it, is that, it's from the complaint, paragraph 1 of the complaint, that plaintiff is a, quote, wife beater and a chronic abuser. And 90 some odd % of the statements at issue in this case do not, involve no allegations of broken bones. And if all of those, if all of those statements are true or substantially true, then and the underlying acts include, punching and choking, then as well as an allegation, which has still never been specifically denied, that he threatened to break Ms. McCracken's nose, that in that universe, the question of whether a jaw or collarbone was broken, and the collarbone statement was then very quickly retracted and I think made to only 1 or 2 people, that in this situation, it is substantially true. I think this would be a very different case if, for instance—
Oh, see, that's funny. And I'm sorry, Judge Beckwith, because this is just a attack.
Yeah.
I want to make sure I understand your point. I would say, well, they're still not substantially true, but he's probably going to have a very hard time proving damages as to those discrete statements where all the reputational harm would seem to have flown for the things that were substantially true. So he might be able to get into court and get to a jury on what's going to end up being a sliver of, maybe that's a little, icing on the cake that is, that icing is false and he could get some damages for that. But really all the stuff that's damaging him is substantially true. And so he should be limited. I mean, that's the way I would think of the argument you just made, is he should be limited to those discrete statements. And I'll give you a chance. I just want to hear why I'm wrong. I should be limited to proceeding on those discrete statements if we get to the second half of the inquiry. And then you would have an argument from the trial court that this is going to be a big, nothing burger of a case because all the harms that he's alleging stem from the substantially true stuff, and this extra stuff is largely irrelevant. No, is that, where am I misstepping?
I would say where I disagree is that I don't think the substantial truth inquiry itself looks at sort of effect on reputation. And although I certainly agree with you to the extent we get to a damages phase, I certainly agree with you, would make those arguments about his lack of damages. His lack of damages also sort of informs the legal question of substantial truth. Just thinking about it hypothetically, if Mr. Giroir were under consideration to be the head of an organization or a government position, and he's, said, well, yes, I did physically abuse my wife over a period of 2 months, and I did all of these things, and I threatened to break her nose, and et cetera, et cetera, et cetera. But don't worry, I never broke any of her bones. It's almost inconceivable to think that that clarification would affect anyone's decision about anything. And again, I think you could imagine this differently if this were, a one-off, bar fight or something like that. And the nature of the injuries is going to be much more germane, not only to who was at fault, but, whether the person acted excessively. I think, there you could, I think it might matter. But here, when the, allegation is, repeated physical violence against one's spouse, including, choking, which, choking can choking can break someone's bone, or, punching can break someone's bone. And so in that situation, and given the allegations here, I think in practice, the reputational harm is not materially greater from those particular statements. And, ultimately, I guess the final thing I say here is, we're not looking at this. The audience here isn't someone sort of looking at the finer points of the, the DC criminal code, right? So the question isn't, well, like assault with significant bodily injury or something like that versus not. You're sort of looking at these things more as a, informed, just as a layperson would hear them, or even a relevant member of the community would hear them. And in that situation, ultimately the broken bone is, if it's purely kind of icing on the cake as you described it, then ultimately the cake is what matters here in the icing. The good icing doesn't save a bad cake, I guess, is ultimately the way I would put it.
My question is much more pedestrian. You were talking about Mr. Gerard's prominence as a human rights advocate.
Yes.
When you were talking about the two different theories. And that made me wonder, I think it's correct, isn't it, that you have never suggested or argued that he was a public figure?
We're not arguing that here. In the trial court, we did with certain we did argue that in connection with the statements made, the non-McCracken statements. We did argue that he was a limited public figure. We are not raising that argument here. We may well, if we are sent back, we may raise it again, but we're not making that argument here. I think, though, even if he is, ultimately, the advocacy on an issue of public concern does not require the person to be, officially a limited, a public figure, limited or otherwise. Certainly, his prominence, though, is one of the circumstances that makes this an issue of public concern. Whether or not on its own, he would meet that standard, although I think there's plenty of reasons to believe he would with respect to, and just to sort of close the loop on that, I mean, if you look at I want to say it's paragraph 18 of his declaration, he sort of goes into great detail as about sort of the statements about domestic violence, talks about it's affected his job prospects. He's been disinvited from speaking at conferences. He's been kicked out of coalitions, et cetera, et cetera, et cetera. It sure seems like the people who work in his field of human rights think that the allegations or the acts of physical abuse are quite relevant to his position as a human rights advocate. And so you don't need to take my word for it. You can see it from what the community thinks itself, as Mr. Gerard himself avers in paragraph 18. Unless the court has any additional questions.
Thank you. We'll give you a couple minutes on rebuttal.
Thank you.
Mr. Gerard, we'll hear from you now.
Thank you. I apologize. I'm recovering from a cold, so my voice is not very clear. I'm Raed Gerard, proceeding pro se as the appellee.
And can you speak up a little bit or, yeah,
Sure.
sorry.
There should be a button on the left, to your left, that can raise the podium a little bit if you need it.
Is-
It might, I'm not,
see
I don't
it.
remember where it is.
But
It's somewhere.
I'll
Okay.
speak up
Okay.
so you can
Thank
hear
you.
me. In today's, my presentation will focus on 2 points. The first one is the standard of review for the court. And the second one is highlighting some of the main arguments that I made in my brief. With the standard of review, like with the oral argument of the appellants, the brief actually doesn't mention what is the standard of review. It just jumps into an expose regarding the letter that I wrote to my ex-wife without actually discussing how the court should value this brief that they are submitting. And, there are 3 different tiers for reviewing any appeal to this court. The first one is the abuse of discretion standard, which gives deference to the trial court on most factual issues. This is, as you would hear, this is mostly an issue of a factual dispute.
I understand your pro se, so I won't drill you on the law, but I don't think that's right. I mean, the question of whether or not these statements were primarily targeted at an issue of public interest or a private matter, we would usually say that's a matter of law,
That's right.
especially at the motion to dismiss stage. Just stop me if I need to explain any of these statements. And that we would review that de novo. I think that's how we've done it in cases like Sarpak and Fells, and those, that makes sense to me. I can look at these statements on a cold record, which is what we have at this stage, and make the same judgment as a trial court about whether or not these things are predominantly private or predominantly targeted toward a public interest. So I wouldn't be inclined, and I don't think our law requires us to give some deference to what the trial court thinks about that. It seems like a legal matter to me.
But Your Honor, I would say there are definitely de novo issues at the case, and there are mixed issues as well. But there are issues that are purely factual disputes. Like, for example, the question that came about my status as a public figure or a limited public figure. That is something that the trial court is saying it needs more development before we come to a conclusion. I say I'm not a public figure, and they say I am. It's not something that should be resolved at this stage of the dispute. There are other issues regarding credibility that the trial court says this is not an issue we can resolve now. The letter that I sent, whether it was coerced or not, my history, other people's history and patterns, these are things that exist.
Oh, for sure. And I didn't mean to express any disagreement with that. As a matter of credibility is out the window, but I don't understand Ms. McCracken's counsel to be arguing that we should be making a credibility determination right now. What I understand them to be arguing is this. The predicate question under the Anti-SLAPP Act is, are the statements that you're attacking things that are primarily targeted at issues of public concern or not? That, I think, is a legal question that
That's
we
right.
review de novo. And if it is an issue of public concern, some of them, maybe all of them, maybe only a small sliver of them, I don't know. We'll have to figure that out. If it is a matter of public concern, well, then you kind of have to get to could a reasonable jury on this record rule in your favor or not? And that's when some of the evidence can come in
right.
to say, well, could somebody read, they highlight the confession in the opening argument. Could somebody read this argument, read this confession, and hear the evidence that you've proffered you're going to bring into evidence and believe you? That is not exactly a credibility finding. That's just saying, is the evidence so overwhelming that a rational jury could only reach one conclusion here? And the trial court didn't get into that because she didn't get the second step
That's correct.
of the anti-SLAPP argument. I don't think we would get into it unless we got to the second step of the anti-SLAPP argument. But I guess the predicate step is purely a legal question of whether or not these were issues of, which was where we spent most of the argument with Mr. Lipper, trying to understand which, all, some, or like the trial court, maybe none of these statements that you're attacking are issues of public concern.
That's correct. And like, Your Honor, to jump into that part of my presentation, I would say the majority of the statements that were made, especially the ones that are actionable that I mentioned, have to do with false allegations of criminal acts that I have never engaged with. Breaking someone's jaw or neck, holding someone as a prisoner in my house. It's some very serious felonies that never happened. The issues of public concern that were discussed, these are not issues that become from different sides of the public debate. It's not that I support violence against domestic partners. It's not that I am opposing raising funds to a charity that works to help survivors of domestic violence. So we do not approach most of the issues that were discussed publicly. We don't come to them from two different sides of the public debate. We actually come from the same debate. As the council said, we are progressive activists who work in the same community. So the assumption.
Do you think it's required that they come from two different sides?
I mean, that's some of the case law and assumptions regarding the anti-SLAPP law is to protect a public debate when two people or two entities coming from different sides of the debate. One is trying to silence the other to, stifle that public debate. What I'm alleging is that these are defamation statements that came from a marriage went wrong, a divorce that is, a very ugly divorce.
So there are certainly some statements that are allegations of criminal activity against another person that are issues of public interest. To give you sort of the first example that comes to mind is, E. Jean Carroll accuses President Trump of raping her
That's right.
as he's on the precipice of becoming president for the first time. Certainly an issue of public concern, and I don't think President Trump would come out and say, I'm of a different view. I think rape is great. He says it's a false allegation. It's not true. That never happened, is his defense. So, but that would pretty clearly be an issue of public interest that the allegation was commenting on, because you have a public figure. So it's not quite right just to say that because she's accusing you of criminal acts, they're therefore matters of private concern, nor is it quite true that because you agree sort of on the badness of those acts as alleged, the fact that you're not on opposite sides of that bottom line issue means that the Anti-SLAPP Act can't apply. I don't think there would be any question in the Trump case that I just outlined. That would be an issue of public concern, and the Anti-SLAPP Act would apply. So what makes your case different?
Your Honor, I agree with everything that you said now, and these are not my main points that I make in the brief. I think to address the allegations against President Trump, there are very different, of course, levels of dealing with a public figure like President Trump and myself, who's like someone who works with a nonprofit, who is not even the leader of the nonprofit. There are different public interests in understanding these kind of allegations. I would be interested in knowing criminal or non-criminal allegations, as we saw this week against a nominee for a very prominent government position. These are things that are relevant to public discourse. But with someone with my private life stature, I think that is different. And now, with my briefing, I do make three main points that I rely on to say that the court should affirm the trial court's position. The first one is that the trial courts correctly concluded that the appellant's statements are not protected by the anti-SLAPP law. And that one, I get into details about statements, being false criminal accusations. There is no one here debating that there was an actual crime that was committed. They're not alleging that. They're not actually saying that their accusations of me committing or accusing me of committing these felonies were true.
Oh, they're definitely saying that.
That I broke someone's jaw.
No. I had a long discussion with Mr. Lipper about those two statements. Let's carve out the broken jaw and broken neck comments. I don't know exactly what the record is. He says one of those was cut back immediately, and those allegations aren't in a lot of the statements you're attacking.
Correct. But my first point is about the false criminal allegations. So that is for me, because that does cross a legal line for per se defamation cases in DC, accusing someone with a felony. That is not true. And I'm saying, unlike the case that you were citing with President Trump, where someone is saying the president actually did commit these felonies against me, we don't have this case here. We have a case where I'm saying I was accused of felonies that never actually happened. So that's one point that I start with addressing in my argument. The other one is that, the issue that is the heart of this issue. Statements arose from a private marital dispute, not a public controversy. And that, I think, is an issue that a part of it is factual, and a part of it is a mixed determination. A part of it is a matter of law. And the trial court has looked into the matter, weighed in the audiences and the nature of the statements, and reached to conclusions in that regards. And what I am arguing is that this court should give deference to the trial court because of the nature of the factual dispute that we're discussing. The other 3 points that I mentioned in this bucket were that, the reference to domestic violence is self-referential, not advocacy. That is something that I had alleged originally, and that's something that the trial court has also found, that these were not really issues of public advocacy. And that the statements from Ms. McCracken were mostly primarily self-interested, and these are whether they were public or private. So that's like the first bucket that I talk about, which is how the statements are not protected by the anti-SLAPP law. The second bucket is how I have adequately alleged falsity to proceed on the merits. And you make an important point about the two-step test that the court has applied, and we didn't even get to the second step because they didn't find the allegations on its face to be enough to move to the second step of the test. But I
Well,
did.
Can I interrupt you? And as Mr. Lipper or, Ms. McCracken and Ms. Smith spend a lot of their brief coming back to the point that you don't actually deny that this abuse occurred. And, they say that you say it's rumors, but you don't say whether they're false rumors. Do you agree with that characterization?
I completely disagree, Your Honor, and I did mention this on the record here. I point out the 3 instances where I disagree. So my clear statement, my position is that I did not engage in any acts of violence outside of mutually agreed intimate activity in the marriage. And the acts of choking or slapping happened within rough sex that we agreed to over years of the marriage. And in my brief, I point out the 3 different places where I make the case during the trial court's proceedings. One of them is during the oral briefing that we had, where the judge also asked me the question, because hearing the narrative that is coming from the counsel makes it seem as if I did not contest this. I have contested it over and over, and this is one of the main issues of dispute here. This is not only a case about the criminal allegations. This is a case where I say I have not engaged in acts of domestic violence, and the acts of violence that happened during the marriage happened within the framework of mutually agreed upon consensual intimacy. And the other side says, no, it happened outside of intimacy. So that is definitely one of the cake, not the icing on the cake. This is something that I care about as well. I think my colleagues and my reputation doesn't only depend on the big false accusations that have been made about me committing felonies like breaking my ex's jaw or neck. But these accusations were made to further the false allegations of me being engaged in this bigger system of abuse during my marriage. So I did deny this, and I'm reiterating now my position, which I made during the trial court. I have not engaged in acts of domestic violence during my marriage, and all of the descriptions that happened in the letter happened for acts that happened during consensual sex.
I mean, the letter refers to abuse, which is usually not the word that people use when they're describing consensual
That's correct.
acts. So I mean, I think part of Ms. McCracken's argument is, if you're at step 2, and I'm sorry to kind of get a little legal again, and the question is whether or not a reasonable jury could rule in your favor. Again, it's not clear if we're getting to step 2. That a contemporaneous confession to physical abuse is going to be the type of thing that is so weighty and really hard for a jury to credit a more opportunistic disavowal of, that no reasonable jury could believe it. I don't know if that's right or not, but I mean, when you say the confession was, at least on its face, the confession does not appear to be referencing consensual acts.
That's correct, Your Honor. And I agree with you that if there was an actual confession that included this kind of statements, it makes it much more difficult for me to get a jury to agree to my big position. But what I allege in my case is that this letter I wrote it, I was coerced to write the letter. And I'm not saying this just out of thin air. I actually have a recorded message with the mediator who helped, was trying to help with the communication between me and my ex-wife, McCracken. And in that recorded conversation, which I included some portions of it in the on the record, we talk explicitly about how my original letter apologized for having these acts during consensual sex, and how I got instructions through him that the letter will not be accepted unless it takes out any mention of sex there and make it very clear. I was told that, you know, any acts of violence, even during consensual sex, were abusive because, you know, for a different kind of categories. So I did record that conversation because I was worried that this letter will be used against me. I'm not disavowing the letter just by saying, oopsie, I didn't mean it. I actually have multiple recorded messages to back up my claim that this letter was obtained under coercion, that I was worried for my career and my kids as an immigrant single father of 2 children. I couldn't fight this fight publicly. It is extremely dangerous for me to be engaging with these kind of allegations. And now I'm living that. Just having this kind of allegations out in the public is very hurtful for my reputation, especially in my line of work. So I agree with Your Honor that if there were actual confessions for these kinds of domestic violence acts, that will make my case much weaker. But what I have alleged and what the trial court has concluded is that we have to wait on the factual determination on weighing my credibility and weighing what happened with the letter and the evidence to a later stage of this trial.
Thank you very much, Mr.
I
Gerard.
have one more thing I wanted to add, Your Honor, if it's
Take another minute or
Yeah,
so.
yeah.
if
I mean,
you
the only thing I
like,
want
but-
to add is, like, in addition to everything that I have mentioned, you know, like the only 2 things I wanted to highlight for the court are the fact that, you know, the appellant's brief does not discuss the standards of review, and I hope you will take, you know, a minute to read my argument about why the court should have more deference because of that. And the other thing is that the brief also fails to address the 12B6 ruling where the court also ruled on two motions. The anti-SLAPP motion was one, and the 12B6 was the second. And the appellants don't even mention the 12B6 ruling at all. And that ruling is very damning, and it is related to the facts that we're discussing now. And thank you for providing me the time to finish my.
Thank you. And I assure you that the judges do read the briefs and we have read your brief. So, thank you so much. Mr. Lipper, we will give you 2 minutes.
All righty, I'll try to talk quickly. Few points I want to address. The one point I want to make just about the declaration is that most of the statements in the declaration are not admissible evidence, and as with any summary judgment opposition, but the anti-SLAPP standard requires not only evidence, but admissible evidence. So for instance, the recording that Mr. Gerard keeps alluding to was never submitted to the court. So he has it, but we haven't heard it, right? And so his characterization of a recording that hasn't been introduced would not be admissible. The same goes for all of the litany of different things that people told him they said or he heard, or all of these things. There is very much of a, many people are saying quality to the declaration, and most of those things are not admissible. And the final point I want to make there is when the declaration was prepared, Mr. Gerard was represented by experienced defamation counsel. So this is not a question of Mr. Gerard being pro se and not understanding how to sort of convert the stuff to admissible evidence. He had counsel who knew how to do that if there were admissible evidence. The second thing is the fact, and if you read the declaration carefully, what Mr. Gerard is saying is the stuff he deleted from the confession said that the things happened, quote, during sex, which is not the same thing as the acts themselves were consensual acts. And so I think it's an important distinction, and I think it goes more broadly to, I think it's not just a question of how heavily the jury would weigh Mr. Durar's written confession. It goes to sort of the logical non sequitur of Mr. Durar's response to the confession. To just like simplify it a bit, if I wrote a declaration saying I was driving the car that went through the red light, and then I later on said, well, they made me take out that I didn't own the car. That's not a logical response to whether I was driving it. And his various statements and his his generalized sort of self-serving denials do not ultimately sort of take precedence over the specific written admissions he made and his failure to address them specifically, or let alone provide some sort of logical explanation for how the material that was supposedly deleted, could affect the things he actually said. I see my time has expired unless the court has any further questions.
Thank you so much. Thank you for your argument. Oh, sorry. Sure. Thank you for your arguments. We're going to take a 2-minute recess or a quick recess, and we will reconvene shortly.
All right. Maybe seated. We'll take a short recess and resume shortly. All rise. Court is now back in session. You may be seated.
All right, thank you for indulging that delay. The third case on this morning's calendar is Capital Intelligence Group, Inc. et al. versus Gerald Waldman. and Gerald Waldman versus Capital Intelligence Group, numbers 22 CV 262 and 22 CV 300. Whenever you're ready, counsel.
Good morning. May it please the court. My name is Mark Balin, and I am counsel for Capital Intelligence Group. Mr. Semler is pro se. However, Mr. Semler owns and operates Capital Intelligence Group. This morning, I'd like to reserve 4 minutes for rebuttal, but of the remaining 11 minutes, I'd like to yield 1 minute to Mr. Semler as he wishes to address the court, if that is permissible.
Okay, and Mr. Semler, were you here when I spoke at the beginning of the last argument to our pro se person? I mean, it doesn't really apply because you're not going to use all 15 minutes, but okay. Right.
Okay, thank you. So we've already heard, quite a bit about the anti-SLAPP statute. This case, of course, also relates to the anti-SLAPP statute. However, in this case, the Superior Court correctly determined that step one, the prima facie case, had been met. And I think that's not a close call here. As a matter of fact, in the legislative history of the Anti-SLAPP Act, there's a reference to residents on Capitol Hill who were protesting a real estate development. And that was one of the reasons why, or one of the reasons that this city council considered in enacting the statute. And so I think there's really no question that the prima facie case has been met, as this case really strikes at the heart of speaking out in a public forum on matters of public interest. And just at the heart of this case is this beautiful mural that was on the wall in the Brooklyn neighborhood. This building is called The Survivor's Journey, and Mr. Semler was very passionate about it and concerned when he saw that there was this development being built in the parking lot next door to that building that was going to block the mural. And that is why, and he knew the building very well. I mean, it's no secret, it's all in the record. He actually tried to buy that building and the parking lot to preserve the mural in part. And that's all set forth in his affidavits, 3 of which that we've submitted in connection with our anti-SLAPP motion. And so that is why he appeared at the community meetings and spoke out against the project. And that is why he criticized Mr. Waldman, the plaintiff in this case, because he believed, as he wrote in his article, or op-ed as I called it, because it's really like an essay, not a strict news article, but in his essay that he published after the meeting, that this represented an effort that he saw by developers like Mr. Waldman that were not sufficiently taking into consideration some of the benefits of DC culture in the last 20, 30 years. In particular, the fact that Black artists and art concerning people of color, which the Survivor's Journey mural actually represented, were being sidelined. Notwithstanding the facts as set forth in his op-ed, his article, there's been all this great development in that respect in the art world. And so it was that that prompted him, and I will admit up front that he sometimes got engaged in ways that perhaps in hindsight he was a little hyperactive at points in the community meeting, but that's where we have to take the context into consideration in that background with him. So number one, Judge Sadler correctly found that this was a matter of public concern and therefore fell under the statute. Number two, she also correctly found that the plaintiff was a public figure. And so, and that again, I don't think is a close call. He was at the meeting, he meaning the plaintiff was at the meeting, he was engaged in the conversations at the meeting, in the public forum. He was advocating a position which was to support this real estate development project that he claimed he was no longer involved in, even though he originally was. But nonetheless, he was sitting there. And then thirdly, there's this question of germaneness, which Mr. Waldman's counsel has raised and argues. But again,
Councilman, I know you want to go point by point, and I appreciate why you would want to do that. But I do think, should we get to the heart of this? I mean, it's the part where you disagree with the trial court. So
Right. Okay.
I appreciate that
I'm
they
happy to
have,
do that. No,
I
I
appreciate
just-
they raise a number of predicate questions.
Okay.
I'm in general agreement with you that I don't think they've got a leg to stand on as to whether or not the Anti-SLAPP Act applies, as to whether or not Mr. Waldman is a limited purpose public figure. And so it all kind of comes down to whether or not he has a reasonable chance of success on the merits, basically a summary judgment standard of succeeding on a defamation claim. And in this context, given his public persona, it's a malice standard. So that's where you disagree with the trial court. And so let's talk
Correct.
about that.
I'm happy to do that. I just wanted, there is a cross appeal, but that actually just relates to the one publication, to one of the three publications. So there are three publications. We have the January 2017 video. There is the June 2018 community meeting that's also a video. And then there's the article op-ed that he wrote also in June of 2018. The op-ed, the article embeds the two videos. Again, just so the record's clear, I won't be arguing much about I guess on rebuttal, because it's a cross appeal issue on that first publication, but the Superior Court was correct in finding that that's barred by the statute of limitations. It was clearly a year. It was published originally on YouTube a year before that video was, a year before the claim was filed. So I'm going to jump right to the two.
That's not exactly their argument about it. They don't disagree with that. They just say we didn't make the claim, but I'll let them address that.
Right.
Okay.
And I can maybe, if I have time at the end, I'll address some of that too now, or I'll address it on the rebuttal, because I think there's no fair reading of the complaint where you put forward a video and then say that, the defamatory statements made up about these issues are being alleged is the claim. But in any event, let me jump to the two publications that we are claiming that Judge Sadler got wrong in her decision. The first is the statements that were made, the commentary really that was made at the June 2018 community meeting. That was, and it's really important. Our arguments here are basically that these are non-actionable statements to begin with. And then if they are actionable, if the court does think that they are false statements of fact, then there's no actual malice by Mr. Semler to support a claim. So first, with respect to the actionability of the statements, it is critical for the court, and this is where I think the Superior Court was deficient. It's critical for the court to give the consideration of the context of those statements. And the context here is a community meeting. You have Mr. Semler sitting in the audience. You can see this on the video. He's taking the video. He has Google glasses, which have a camera on his glasses. And so he's sitting in the meeting and he's videotaping the meeting. You can see Mr. Waldman is also in the meeting, sitting a couple of rows back and to the side of Mr. Semler. And then there are people, the developers or the representative of the developer, who's standing up front, along with perhaps, I think, the head of the community organization. It was, I think, the Brooklyn Neighborhood Community Association. That's the setting. You have people who've come, neighbors who've come, and they're all upset. You can see it in the crowd. You can hear it about this development. And they're mostly upset is because they just found out about it. And this is an issue that strikes at the heart of communities all across DC over the last 30 years, the gentrification of the city and the displacement of communities. And people rightfully, I think, should be allowed to come to meetings and express their concern and maybe even their anger. And that's what people were doing, including Mr. Semler. And it's that meeting where the developer was making statements about his development. And then at certain points, Mr. Waldman interjects and gets to support the developer. And again, he claims he's not a developer, he's not the developer, but he interjects. And that is when Mr. Semler makes, other comments. A lot of the comments that they have identified were not directly about Mr. Waldman at all. It was just sort of about the process. And, I can highlight a couple of those for you where, for instance, this is corruption Brookland style. They allege in the complaint Brooklyn, as in Brooklyn, New York, but what Mr. Semler actually said was Brooklyn style. That's just an expression of frustration. It's not a direct statement of fact about anyone. This is corruption Brooklyn style. That's an example. The other thing, another statement was that they're doing things under the table. They're doing all this stuff under the table. That again, it's alleged in the complaint that that was directed to Mr. Waldman. But if you watch the video and you listen to the words, he does not say Mr. Waldman's name. He uses the word they. They are doing everything under the table, meaning the developers, perhaps, the city council, the ANC commissioners. Mr. Semler was very upset about the government officials who are approving these projects.
Is it clear that Mr. Waldman is not included in that they?
I'm sorry, was it?
Is it clear that Mr. Waldman is not included in that they?
Well, when you say, is it clear, I would argue, frankly, if you watch the video and see how everything is going on there, nothing is entirely clear. And I think plaintiff even concedes that when, I think in a footnote, he says it's not clear what was said in this word, in this sentence here, because that's sort of how community meetings work. People are saying things, other people are over talking and so forth. The famous case, the Supreme Court case, Greenbelt Publishing versus Bressler, where the Supreme Court said that at a community meeting regarding a real estate project, someone accused the developer of blackmail. But in that setting, they said it's not actionable. It's rhetorical hyperbole because it's just hard to see what is going on. This is not a New York Times investigative report that found that Mr. Waldman was doing things under the table. This was people shouting at a community meeting. And again, it got heated at times. But these were not direct accusations that were researched, and the people who are listening to it would view it as something that is a statement of fact, that is a definitive statement of fact. It's colorful language, corruption Brooklyn style. They're doing things under the table, things like that. It's not the kind of direct statements that frankly, if you look at some of the other cases that this court has reviewed in the anti-SLAPP context, where it's been written reports from think tanks or from hired guns for campaigns who are writing dossiers. That's not what this is. That June 2018 hearing community meeting was sort of a bit of a free-for-all, and Mr. Waldman himself was very active and engaged in it. And he was, sort of shouting back and he was defending himself, but also lodging criticisms to other. So I feel
like we haven't really gotten still to the heart of it. I mean, I think what the trial court's ruling is, well, look, there are some specifics in there. Having troubles with the DOJ, being investigated by the U.S. trustee. Those are not so flowery and uncertain. Those are fairly specific. And I think the trial court's reasoning was, well, there's really no reason to think either of those things were true. And so what's your reaction to that?
Yeah. Well, I'm going to agree with you in part and disagree with you in part.
Okay.
And I think it's a great point. And I was going to get to that because the statement about the U.S. Trustee's office really was made. There was some vague reference to it at the community meeting, but it's clear as day, and I will admit that in the article in his op-ed, he clearly states that he is subject to a criminal bankruptcy fraud proceeding in the U.S. Trustee's office or something to that effect, or investigation in the U.S. Trustee's
And
office.
subject to is the language?
He's subject to, yes, right. Actually, I should read that exactly, just so the record is clear. The statement was Waldman dash, who is the subject of a criminal bankruptcy fraud complaint with U.S. Trustee of the Department of Justice for the Northeast property, better known as the former Brooklyn Inn BBB, has repeatedly said that he sees no reason to preserve the iconic survivors mural. Okay, so I will agree with you. That's a statement of fact. We're not backing away from that. But I would argue that it's based on the evidence that's been presented in this case. And Judge Sadler granted their request for limited discovery. They were permitted limited discovery to build the record. And so this record is basically built on what they have created. I would argue that it's true, or at least they can't prove that it's false. They don't have sufficient evidence to prove that it's false. But even more importantly, and this is the argument that I think is the slam dunk, so to speak, is there's no actual malice. Mr. Semler made made the complaint to the US trustee's office. There's no question about that. We have the affidavits that say, that admit that they spoke to him, that he came and talked to them. Mr. Gazinski is one of the US trustees, talked about the fact in an email that has been produced that this claim was made. And then the linchpin of it all is the affidavit of Bradley Jones, which we've cited in the record. And it's, he clearly says that, he says he doesn't quite remember everything. He acknowledged that he spoke to Mr. Semler, and he said that in those types of situations, he would tell the person who called him that he was looking into it. He would look into what they are doing, what they claimed. He would look into it. And again, let me read the exact language, because he said that he said, quote, and this is paragraph 21 on 7J Joint Appendix, I think it's 701, or it might be 703, but it's paragraph 21 of Bradley Jones' affidavit. He says he would have stated that he would have stated to Mr. Semler or someone like him that we were reviewing the documents that defendant sent us, defendant meaning Mr. Semler, and looking into the allegations that he made.
Doesn't that sounds sort of like in the future? And doesn't the record show Mr. Semler was basically frustrated that nothing was happening? And that's why he was making these inquiries?
So certainly he was making inquiries. I think, and perhaps he was frustrated that he hadn't heard anything, but he didn't know that nothing was happening. And based on what Mr. And again, when you say nothing's happening, I think he was he was frustrated that there hadn't been like an indictment issued or something to that effect. In other words, there hadn't been action. But there's nothing in this record that shows that Mr. Semler was ever under the impression that they were not investigating. They were not looking into it. I mean, he does have some distrust of government officials and so forth, but he believed, and he says this in his affidavits, that after he told them what he experienced, that they would look into these. They would look into this, that they were investigating it. And again, there's nothing in the record that says to the contrary. And this is for the actual malice, it needs to be clear and convincing evidence that there is, like for instance, in the Hart-Hanks versus Kanaan, or even in the Mann case, where you had those investigative reports that said this is contrary to what the defendants wrote. There was physical evidence. Hart-Hanks versus Kanaan, same thing. They had these transcripts that contradicted what the newspaper had reported. There's nothing here that contradicted what Mr. Semler said. Granted, the US trustees have claimed, well, we would never, it's our department policy that we don't tell people details. We won't say what's going on in our investigations. But that doesn't mean that he had concrete evidence or there was any evidence to show that he didn't believe that this investigation was going on. So, and the other thing about the reason why I believe the investigation was going on, not only the statement under oath by Bradley Jones, the assistant US trustee, but also when we subpoenaed the records from the US trustee's office, they asserted work product privilege. And I don't think the court needs to rely on that, because the evidence that we've shown so far doesn't get the plaintiff to where he needs to be to make his case. But clearly the fact that they're asserting work product privilege, which means that it's under Rule 23, that means it's 26 rather, it means it's in anticipation of litigation or trial. Certainly means that they believe that there was something going on there. Otherwise, I don't believe the work product privilege would have applied. But again, I don't think the court needs to even go to that, because there's not even a scintilla of evidence to show that that statement is provably false, number one, and number two, that there was actual malice. Now, and they point to the emails that Mr. Semler sent, but again, there's nothing in there, those emails, that show that Mr. Semler expressed any indication that he didn't believe what he said. So for all these statements, they're either non-actionable because they're opinion or rhetorical hyperbole, or just not about Mr. Waldman, so not about the plaintiff. Or if they are a statement of fact, there's nothing in this record that shows that Mr. Semler was under the belief that what he was saying was false or inaccurate in any way. And he had knowledge of what happened. He was involved with the transaction that he was complaining about. So he had knowledge of that. And in his mind, there was criminal activity, there was fraud. That was in his mind. Now, Granted, the U.S. Trustee's Office hasn't done anything on it even till now, but he's written letters to the Department of Justice, which is in the record, the Attorney General rather. So he's always stood by his belief. And we've got 3 affidavits where he has expressed those sentiments. And again, they were given limited discovery. They did not take his deposition. They did not test the veracity of those affidavits in any way. And so in this instance, there's just zero evidence of actual malice. And for that reason, the Superior Court's ruling on the second 2 publications should be reversed and judgment, the motion should be granted in favor of Capital Intelligence Group, which is the publisher of the article, and Mr. Semler, who was the author of the statement.
Thank you very much.
Unless anything further.
Mr. Sumner will give you the 1 minute you requested, and Mr. Balin, we will give you a couple on rebuttal, so even though we let you use them up, so.
Good morning, good afternoon. My name is Peter Summer. I've been a professional journalist since when I can remember. I worked for the Sunday Times of London. I launched Bloomberg Business News in Italy, worked for 60 Minutes. I was involved in the founding of Merger Market, the world's leading mergers and acquisition deal newswire. And now it's the 3rd largest news agency by journalists. It was bought by the Financial Times and they sold it to Carlyle Group, and now it's worth $25 billion from my last read, but it started out as a startup in Brick Lane, London. So I was involved in opening that. But I'd like to open my statement on, since we're going to be celebrating Martin Luther King's birthday on the 20th, his speech, "I've reached the mountaintop." King spoke about the centrality of the First Amendment for our rights, how that makes us different from China and Russia, that the First Amendment, he says in 1968, this is 68. I read of the freedom of assembly, somewhere I've read the freedom of assembly, somewhere I've read about the freedom of the press. Our anti-SLAPP statute is fundamental for Washington, D.C. I'm a 4th generation Washingtonian. I live in Ward 5 in Brooklyn. I take what we're happening. I mean, in fact, as you know, on this court, a lot of the issues in Ward 5, 7, 8 is completely ignored. And a lot of the things that we've seen now today in 2024, so we've seen in the 70s. And a lot of what I wrote in the article has been true. A lot of the issues I've raised, you're now looking at that in your court dockets. I don't mean the record. And just reading the totality of my story, there's nothing liable, nothing to defend. In fact, I have no malice for Waldman because my targets is our chairperson, Mendelson. It's about the bankers. It's Maxine Waters and using the community, the CRAs and applying the laws equally. And that's what I was doing. I mean, mostly I do M&A. I'm now in Ukraine a lot. I go back, Kharkiv. In fact, the suit is taking a lot of resources and time away from that. And, I'm here pro se because most of these times the reporter, the person who writes the story, the messenger is gagged, put on the sidelines. In fact, I'm now involved with the film Wars of War with Anna Politskaya, the Russian journalist who was murdered in 2006.
One of the things in the Court of Appeals we tend to avoid is fact finding though. So we deal with legal arguments and.
No, I know, but that's why journalism is so different. We have the ability to go 360, which we bring people together. I'm bringing Rubenstein together with the members of Nina Anishinaabe, the #1 Black woman artist in the world. She's in Art Basel, Miami. And
My only
Rubenstein,
point is everything you're saying is not relevant to our consideration
Oh.
unless it's in the record.
but that's whole part of the whole story. That's what we're debating about. It's not just one, it's the totality of the article. And any judge reading it and everybody who's read it would say there's no liable defamation, dismiss it, anti-SLAPP, and we're not in this position. Okay,
Take your
thank you.
point. Thank you so much. Yeah. We'll give you a couple minutes on rebuttal and we'll hear from Mr. Nagy. Did I pronounce that correctly?
You did, Your Honor.
Your Honor, no, I recognize the appellee typically doesn't get to reserve any time for rebuttal, but due to the cross appeal, if I could reserve 1 minute.
Okay, usually we would just have that covered, but yeah, oops.
Well,
No,
however
that's
you
fine. That's good.
Honor,
We'll give you,
prefer to proceed.
it'll work. We'll give you at least a minute. for
Okay.
rebuttal.
Thank you, Your Honors.
Mhm.
All right, Well, we've heard a lot about the anti-SLAPP statute, about the legal standards, the first prong of it in particular as to whether there's a public controversy, and then a bit of a deep dive into the merits. I do want to talk about both of those prongs because I think they're both incredibly relevant and grounds to affirm the lower court's decision in denying the anti-SLAPP suit. But the most critical here is really got to take a moment to correct a few errors in the record as explained by Mr. Balin. In particular, he's arguing that the actual malice standard cannot be met because there's not a scintilla of evidence that Mr. Simler ever had any doubts to the truth that Mr. Waldman was under or subject to a criminal complaint. A statement that Mr. Balin has admitted was made as a statement of fact, published online. Well, we know that is false. There is a great deal of evidence in the record. The sentence immediately preceding the declaration paragraph that Mr. Balin read from Mr. Jones states, I would not have stated whether or not any party was under investigation by the USTP or the Department for bankruptcy fraud or any criminal matter. And that's consistent with other paragraphs of the declarations of Mr. Jones and Mr. Kaczynski, who explain in detail that, yes, they spoke to Mr. Simler a few times when he called them. No, they did not tell him.
What's the false statement again?
The false statement?
Yeah, what's the false statement that this all speaks to? That he's subject to a criminal complaint?
Correct.
Did Mr. Semler not make a criminal complaint
He did
about
not.
Mr. Waldman? What do you mean? But when he talks to the USTO, the US trustee, and says, I think this was fraud. I think Mr. Waldman was part of it. I'm happy to make, help pursue a prosecution. In what sense is that not a criminal complaint?
Well, so in a few senses, as Mr.
It only needs to be true in one.
Yes, but as Mr. Balin explains, you have to look at the context. And as our First Amendment jurisprudence and defamation jurisprudence explains, you look at the context to which the hearer, the listener, or the recipient of the publication would consider it. Now, a statement from a 30-plus year award-winning journalist that someone is subject to a criminal complaint, that includes specific terms of art, specific meanings, that implies, if not outright states, that there is something much more going on than that same journalist.
There are
throwing
terms
in
of
a
art
tip.
that suggest they mean more than what they are. What does that mean? Subject to a criminal complaint.
A criminal complaint, Your Honor, as you're aware, even from the first argument today, a criminal case involves a prosecution. It involves
It can.
actual.
I can make
Sure.
criminal complaints, though. I can call the 911 and complain about crime in my neighborhood. And if you're spouting off at the mouth at a neighborhood meeting, people tend not to speak so precisely. Subject to a criminal complaint is not a term of art that I'm familiar with. Criminal complaint was filed against him is a term of art I'm familiar with. He's been indicted is a term I'm familiar with. Subject to a criminal complaint sounds like somebody who's running their mouth
Well, also-
and have made a complaint about a crime.
Well, Your Honor, respectfully, I disagree, and I believe a reasonable jury properly instructed could also disagree that that was the meaning conveyed. And in particular, these terms weren't just that, although that was one of the written statements in the online written publication, but also subject to criminal investigation and committed bankruptcy fraud.
Yeah, what's false about that? Subject to criminal investigation. I called the USTO, made a complaint, including criminal complaint against Mr. Waldman. They did a little bit of something. They said they at least give it a perfunctory look. And even if they didn't do that, like, is it not clear that Mr. Semler is sincere in his, I mean, he might be out to lunch, but there's no doubting his sincerity that he thinks Mr. Waldman screwed him over in this deal based on the record evidence that we have, and that he thinks he's some version of a fraud or a thief, that he makes a criminal complaint, that some modicum of investigation goes on. And then the record's totally silent about how much investigation has occurred to the extent that we just don't know. So I don't know how we could say a jury could conclude based on what we know that that is actually false, and plus Mr. Semler is malicious.
Well, Your Honor, there's two reasons for that. First, respectfully, I disagree that Mr. Semler is sincere and that the record does not include significant evidence where a jury could find that Mr. Semler is insincere. His contemporaneous emails. Let's start this off with the very first alleged criminal complaint, as you say, that he sent to the U.S. Trustee's office, did not mention Waldman except to say Waldman was aware of Ransom, the owner of the building's supposed fraud.
Right, he doesn't think Waldman's been on it at the beginning.
Correct. And then his later emails, which are outlined at page 34 and 35 of our brief with record sites, are Mr. Simler asking and even then begging for some kind of investigation of Waldman, including saying he's available to come in because Mr. Simler has not yet even been interviewed, which of course is absolutely necessary for any sort of criminal investigation when the supposed crime that was reported was fraud in an oral contract with Mr. Simler.
I mean, I think people who make criminal complaints, victims of crimes, are quite frequently agitated by the delay of the process. So they want things to move and they're not moving. They'll make calls and they'll get upset. It doesn't mean that they know the case is dead. It doesn't mean that they know no investigation is happening. It certainly doesn't mean that they know that no investigation has happened, which seems like a counterfactual in this case.
Well, Your Honor, respectfully, Mr. Simler was told by Mr. Kaczynski and Mr. Jones, and Mr. Simler, due to his years of journalism, should have understood, or a reasonable jury could believe and infer that he understood, that the U.S. Trustee's Office does not even have the ability to pursue a criminal complaint, that that's not its role. Any criminal complaint must be referred to the Department of Justice. So Mr. Simler being told that and yet resting, and say in his own declaration, Mr. Simler finally explains the alleged kernel of his true good faith belief, as he puts it, is that Mr. Kaczynski and Mr. Jones never told him that Waldman was not under investigation. But they did tell him that they could not tell him whether he was or not. And as the experienced journalist he purports to be and wishes to be judged on, he should have known better and would
No,
have known
that's
better.
not the malice standard.
Well-
I mean, you're slipping. I would agree with you that he should have known better is probably a standard you could satisfy here, but it's not the standard that's applicable if you've got somebody who's a limited purpose public figure. Maybe he should have known better not to say something when he didn't know whether or not it was true. But if you don't know whether or not something is true, you can't be maliciously like publicizing a false statement.
Well, you can, Your Honor. That's the reckless disregard part of it. It does not have to be subjective.
Do we even know that he wasn't investigated by the U.S. trustee?
Well, we have indications of it from the record. Both parties did.
Sounds like a no to me.
Well, Your Honor, we can't prove a negative, and we're not required to under DC law when there is an allegation of criminality. We don't have to prove he was never investigated. We just have to show that Mr. Simler recklessly disregarded indicia that should have called that into doubt.
What called that into doubt when they said they would at least would have looked at they would have taken the complaint. They would have looked into it. How is that not at some investigation?
Your Honor, investigations are significantly more than that. In particular,
Sometimes they're quite brief.
well, yes, but an investigation of a complaint of fraud related to an oral contract must necessarily include talking to the supposed victim, the only counterparty to that oral contract, and yet that did not happen.
Why must it necessarily include that?
Well, because
I mean,
how else
what
can
if
there be an investigation?
what if they investigate and they realize that this person is a serial liar and they don't believe him? They've investigated, and case is dead. Or what if they go and look at the alleged forgery and say it matches up perfectly? The bankruptcy judge has already dealt with this. We're not interested in this. We're done.
Okay, well, two things with regard to that. It's inconceivable that had the U.S. trustees actually investigated and found anything to constitute the necessity for a criminal referral to the Department of Justice.
He doesn't say that though. He doesn't
He
say,
does. He
he doesn't
says
say they
subject to a
investigated and
criminal
referred him.
But he
I
says
made a
subject to
criminal
investigation.
complaint and they investigated.
And he also says subject to a criminal investigation that he made this supposed complaint to people who are not empowered to conduct a criminal investigation.
Where's the subject to a criminal investigation?
These are the various shouts in the video.
Can
at the
I just
scene.
clarify one thing
Yes, sir.
factually about that? Is it subject to or the subject of, which,
Pardon me, subject of is in the written statement.
okay.
And that is also important and a distinction that does matter because that
Seems
could
like we're
include-
all subject to, I mean, or could
Well,
be,
well, I suppose, but subject of includes, as a predicate that there is actually an investigation and that Simler has some knowledge of there being an investigation when the record evidence indicates that Simler has no reason to have a good faith belief there's an investigation. He's been told that they cannot confirm whether there is or not, and he has not been asked to participate in anything related to a criminal investigation. Moreover, the dockets include no indictment, no any reference, and the bankruptcy docket includes no reference other than Simler's own letter immediately after the suit was filed to the then bankruptcy Judge Teal, asking for Judge Teal to investigate because the trustees apparently had dropped the ball in Simler's mind. This is a man whose actions, since the suit was filed, since the defamation was published, further show that he did not honestly believe there was a suit. Now, maybe he really did.
I'm
truly
sorry,
believe
just
that.
give it, there was a suit?
There was a criminal investigation since the suit was filed, that he
Again,
did not honestly
I
believe.
just want to get really specific about the words because they matter. They matter in a defamation case where malice is at stake.
They do, Your Honor.
If I recall correctly, it was subject to an investigation by the U.S. trustee, not a criminal investigation by the U.S. trustee. It was subject to a criminal complaint. Were the two phrases that I think we're talking about. Both those things strike me as, if not clearly true from the record in at least some respect, in the sense that he made a criminal complaint and the U.S. trustee did some modicum of investigation into it. Getting to malice. I mean, if you say, but they were irresponsible, he acted despite not being sure that they were right. That's not reckless disregard for them being, he would have to basically be on notice that they're false. And I don't think he's on notice that they're false because I don't think they are.
Well, Your Honor,
And unless you add glosses to them like, oh, it suggests that there's sort of a booming investigation into him. These are generally offhanded complaints at a town hall meeting. And what I hear from Mr. Semler is, Mr. Waldman is a crook, he's a thief, he screwed me over, don't believe a word he says. Roughly what he says. And if you want to take words like that and say, well, technically fraud is this and that, and he can't actually approve that. And, that's the whole doctrine here of malice in a defamation case is meant to stop stuff like that. Like people get to run their mouths a little bit.
well, Your Honor, people do get to run their mouths to some extent, I suppose, but defamation per se exists for claims of criminal culpability for a reason. It impugns a reputation far beyond any sort of running of the mouth or any sort of spirited debate at a public meeting. These are statements that whatever you think about what was said out loud at the BNCA meeting, Mr. Semler then went home, wrote up a new article, wrote up what he has now argued before you is actually intended about other people, not Mr. Waldman, but general concepts of gentrification, and yet chose to include in there specific allegations of fraud, corruption, criminality, and investigation by the U.S. Trustee's Office.
Which specific allegations? Can you just give me your language?
Well, subject to a criminal complaint.
Yeah, we've covered that one.
And claim that he was committed fraud.
Does it say criminal fraud?
I don't believe it uses the word criminal right
There's
before
civil
that, but it
fraud.
used criminal in the concept.
I mean, again, is there really any serious doubt on the record evidence that Mr. Semler thinks he was screwed out over this property? He was screwed over?
Well, there is, Your Honor, that he was screwed over by Waldman. Yes, there is. He may have been screwed over by Ransom, the previous owner. But the record, the contemporaneous emails before the foreclosure auction and immediately after the foreclosure auction are Waldman agreeing to meet with Semler proposing various business plans, Semler writing that he specifically is not going to attend the foreclosure auction, Semler having his attorney, Benny Cass, reach out to Waldman, asking Waldman to make a side deal with Semler. And then after the foreclosure auction, Semler writing Waldman and saying, hey, congratulations, you've got this. Now let's talk about my business deal and see how we can get this together. And by the way, we've got a ticking clock with a 1031 exchange for tax purposes, so we got to get this done right away. Well, Waldman didn't like the terms Mr. Semler offered. And so it didn't happen. And at that point, that's where Semler changes his mind. A reasonable jury can look at Mr. Semler's contemporaneous statements at the time when he says he was being defrauded and see no indication of any sort of fraud, criminal, civil, or anything. All they see, all a reasonable jury can see, a reasonable jury properly instructed can take that evidence and can infer that Mr. Semler is simply grinding up private acts and co-opting public discourse to do that. And with regards to that, Your Honor, I realize I'm getting lower on time, but I would like to pivot briefly to the first predicate of the anti-SLAPP statute. Now, yes, Your Honor.
Can I just follow up on one thing that you mentioned? You were talking about your understanding of the reckless disregard standard.
Yes, Your Honor.
And I guess how we usually think of it is reckless disregard for the truth. You think, there's a statement that was made, a defamatory statement, and we all assume or know it was false, and the person who uttered it, we're evaluating to what extent they knew it was false. You seem to be saying, admitting, I think, conceding that we are not sure what the truth is here, but he still, we still could find and must find, in your view, reckless disregard. Because it's just reckless disregard for whether it is true or not. Does that accurately summarize what you're saying? And if that's correct, can you point me to cases that discuss this kind of nuance?
Certainly, Your Honor. So it's the Hall case at 867 F3D at 149. I'm sorry, I don't have the whole site, but it's in our brief. That explains, that's the district, the federal district court for DC interpreting the District of Columbia's law and explaining that, well, look, you don't have to prove a negative when it comes to accusations of criminality with respect to this reckless disregard. It's just too hard, because how to prove somebody didn't do something that was criminal, you don't have to do that. Instead, the report of the crime, the report meaning the publication, the accusations of it that is allegedly defamatory, can be made in bad faith or with a reckless disregard of the effect on the defamed, so on Waldman in this case. And when we get to the greater, or the, I guess, taking it up a notch to more 30,000-foot view of the concept of reckless disregard, in some of those cases, the Court of Appeals here has developed quite well as the U.S. Supreme Court. So Hart-Hanks Communications, Inc. versus Connington, that's a 491 U.S. 657, and also in our brief. It explains that a reckless disregard, in order to meet this actual malice standard, that reckless disregard can be satisfied where there's evidence showing that the publisher, so Mr. Simler in this case, had serious doubts as to the truth, and that evidence can be inferential by proving a, quote, high degree of awareness of probable falsity. Now, Your Honor, here, I do believe that there's evidence in the record, which our brief goes through with a great deal of exhaustion, showing all of these indicia that challenge and all of these potential inferences, including Mr. Sumler's contemporaneous statements and the uninterested statements and affidavits of the third parties, Mr. Kaczynski and Mr. Jones, who Mr. Simler, again, claims in his affidavit is the sole reason he believes there was an investigation, because they never told him there wasn't. Those are his words, yet we have all of this inference that Mr. Simler apparently completely disregarded, that those same people told him, we can't tell you one way or the other. And by the way, we're not asking you follow-up questions. We're not doing more than this. And Mr. Simler's writing them even years later, hey, can I come in for an interview? I want to pursue this. Indicating, words pursue, these future verbs, indicating Mr. Simler at the time before his publications defamatory to Mr. Waldman understood that something was not happening. Now, can we prove a negative? Perhaps not unless the U.S. Trustee's Office decides, to open it. I suspect the Department of Justice would object to that, and what a huge fight. But that's something after the anti-SLAPP statute. The anti-SLAPP statute, the part is, have we adduced enough evidence into the record that a reasonable jury properly instructed could conclude that this weight of evidence undermines Mr. Simler's credibility and is enough for the jury, a reasonable jury, to conclude that Mr. Simler simply is not being truthful when he says he believed Mr. Waldman was either the subject to investigation or was not being truthful when, or that Mr. Simler had the high degree of awareness of all of these other factors and indicia that it was not a true statement, yet proceeded anyway. And that's the test we're at, not whether we've shown enough at this point in time to ultimately prevail, but it's whether we've shown enough that the reasonable jury operating something, I believe Your Honor, Judge Deal described it as something similar to a summary judgment standard. Mr. Waldman, as the plaintiff, gets the inferences. Nothing in the standard allows any inferences to Mr. Simler. And with those inferences, a jury could conclude that Mr. Simler acted with actual malice. And that's the key here for the second step that the Superior Court got right. Now, I know we went down quite the rabbit hole, but if I may still very briefly address the first part of it.
Okay.
Well, Your Honors, I think this argument about the actual malice and the actual statements, if it shows anything, it's that this is a private dispute between Simler and Waldman, and that it's based on whether or not Simler feels, to use Your Honor's language, screwed by Waldman with respect to purchasing a building that a different developer later developed. So to say that it's some kind of foregone conclusion that there's a public debate or the first prong is met, I think glosses over the fact that this although a BNCA meeting where a different developer other than Waldman announced a project that it was building as a matter of right. And at that meeting, yes, Mr. Waldman, as a neighbor, did speak up. But does that mean that any neighbor, anyone in the community who speaks up at any public meeting is immediately a limited purpose public figure with respect to that? I mean, our jurisprudence doesn't say so, and Mr. Simler has not cited any case saying that that becomes that broad. Certainly not under the anti-SLAPP statute. And then you go to the limited purpose public figure part if you even cross that first threshold. And again, the limited purpose public figure, the alleged defamatory statements must be germane to the public controversy. To the extent the public controversy, as Mr. Simler explained here, right in front of your honors just a few minutes ago, had to do with gentrification and generally pushing out or perhaps people out of their homes, or maybe minimizing the historical impact of African-American art in these communities. Well, whether or not Mr. Waldman defrauded or somehow purchased the Brooklyn Inn, with a credit bid, since he was the secured lender at auction instead of Mr. Simler, has nothing to do with whether a new developer with a perpetual easement preserving the view of the mural, what does that have to do with their private dispute? It just simply, there's no link between calling Mr. Waldman a fraud and saying he's subject to the criminal investigation and the actual potential controversy of the public aspect of a developer who's not Waldman building in a parking lot, mind you, not tearing down homes, but building in a parking lot, new condos, new homes in a building in a way that won't obstruct a mural. Your honors, I just don't see it. And I ask you, really ask you to look closely at that first prong, because quite frankly, the facts in this case are messy, but that first prong is the easiest off-ramp you have. There simply was not public controversy. And to the extent this was a public controversy, Mr. Waldman was not a limited purpose public figure. Therefore, you don't even have to deal with the facts of the actual malice, and let the Superior Court then continue and develop the factual record. And maybe Mr. Waldman doesn't prevail, but he certainly has shown enough at this early stage that the purpose of the anti-SLAPP statute is not being met 7 years later by dismissing the suit on these grounds. All right. Thank you, Your Honors.
Thank you. And we will give you 1 minute on your rebuttal.
Thank you, Your Honor. Through this whole presentation, I didn't hear the word once, and maybe I missed it, or the phrase, clear and convincing evidence. But that is part of the standard, and that has to be applied at the anti-SLAPP stage. The Mann case said as much. So when the jury considers the evidence, it has to be clear and convincing evidence. The plaintiff has to put forward clear and convincing evidence. I'm not going to concede that anything that counsel just said is actually evidence of either knowledge of falsity or reckless disregard of the truth by Mr. Semler. But it certainly has not reached the stage of clear and convincing evidence. The cases that Mr. Nagy cited, for instance, Hart-Hanks versus Connaughton, I also cited that because in that case, there was evidence, there was physical evidence, there was a transcript that had contrary information to what the publisher published. And therefore, the court, Justice Stevens, I think it was, who came around to the conclusion that, hey, they had facts in their possession that were contrary. Mr. Semler had no facts in his possession. What he had was a vague statement from the that they claimed that they made in the affidavits that they would have told him that they were not they couldn't disclose whether or not they were investigating. But we do have in the affidavits that they told him that they were going to look into his complaint and ask him for, information, collect documents and look into his complaint. And so the issue here is, again, whether or not there was clear and convincing evidence of either knowledge of falsity or reckless disregard of the truth. And that's another thing where counsel, references reckless. He was reckless, or he had reckless disregard. It's reckless disregard of the truth. And in St. Amant versus Thompson, the court defined that as having substantial doubts about the truth. So they'd have to show that there's evidence, clear and convincing evidence, that Mr. Semler had substantial doubts about the fact that his criminal complaint was actually that Mr. Waldman was subject to a criminal complaint, when he in fact made a complaint to the US trustee's office. I think there's just no way possible that any jury could ever find that. He made, there's no dispute that he made a complaint to the US trustee's office. And therefore, in his mind, he believed that. He said that in his affidavit. They didn't take his deposition to try to cross-examine him in any way. So there's no evidence here there's no clear and convincing evidence. At most, there's speculation and there's inferences built on inferences built on inferences. But that's not the type, if you look at the cases that your honors have been involved in directly, but also by the Supreme Court and elsewhere, where there's a finding of clear and convincing evidence, there's typically a document or a direct statement that's contrary to what was said. And that's what we're lacking here. The other case he cited, by the way, the Hall case, that was the standard there was negligence. And so it was not actual malice. It was about the employee, the customer at a restaurant who was accused of fleeing on her bill. And that was, and the restaurant there, even had her credit card. She left her credit card as on the tab. So they had evidence, the evidence there was that the restaurant knew that this woman was not fleeing on her tab when she left her credit card, and they could have simply just charged her credit card. So that case is completely distinguishable and is not an actual malice case. And so that has no bearing here. Just briefly on the first prong stuff, I really don't know where to start because Mr. Semler, went to a public community meeting. He mentioned the things he mentioned about Mr. Waldman because Mr. Waldman injected himself into the controversy by making statements, and Mr. Semler, doesn't believe in Mr. Waldman's credibility, and he made comments to that effect. So this is directly related, and if you look at in the public figure analysis, that third prong, that germaneness prong, this court in Stockard versus Moss clearly said that it's a very wide berth of germaneness, and there has to be a showing that the comment or the statement was just wholly unrelated. So to give you an example, if Mr. Semler went to the meeting and said, Mr. Waldman's a pedophile, okay, I would say that's probably not germane to the subject here. But what he was talking about was what Mr. Waldman had done with respect to the very property that is being discussed at the meeting. I mean, this is not, even unrelated. It's certainly not wholly unrelated. It's not even unrelated. It's directly related. So I think that Judge Sadler absolutely correctly made a correct ruling on the first prong, the prima facie. She was correct on the public figure, which she I think came up short on. And frankly, she gave the plaintiff, every ability to try to build their case on it, on the actual malice part. But she, I think, incorrectly applied that portion of it. And so for the statements in terms of whether or not a jury could conclude based on clear and convincing evidence there's of actual malice, it's just not there. And for that reason, the court should reverse the ruling on the motion, the anti-SLAPP motion that denied it in part and deny it and grant it in its entirety. And just one last thing on this portion of our brief, we threw this in at the end about the motion for security. Again, I understand the jurisdiction. We don't have interlocutory jurisdiction. I'm not saying we do. But if the court does grant our request on the anti-SLAPP portion, then I would argue it is a final order. And it is something that I would suggest the court review, because I do believe, and it's not just Judge Sadler, but my experience with other judges in the Superior Court is they're not applying this statute correctly. And this is the statute that basically says if there's an out-of-state plaintiff, in this case like Mr. Waldman, that they are required to post some type of bond and so forth. And as far as I can tell, very few judges in the Superior Court are interpreting that correctly and are enforcing the law. And so I just put that in there for that purpose, but I understand it's not necessarily right for appeal unless the court rules in our favor.
Thank you, Mr. Mallon. And Mr. Nagy, do you feel the need for rebuttal?
Yeah, well, just very briefly for
Sure.
the cost appeal.
Sure, yes.
In particular,
Yeah.
since your honor had asked about
Yes.
them earlier. So the motion for security part, I'll say we'll rest on our brief. I think those arguments are all in there. With respect to the cross appeal issue, that Escala Cafe, I said, I don't know how we could have been more clear when after Simler filed his opening Rule 12b-6, or in the alternative, anti-SLAPP motion to dismiss, saying, hey, there's a time barred claim. Mr. Waldman immediately in his response said, no, I'm not bringing that claim. I'm disclaiming that claim. I'm not reserving it.
Can I ask why you care? I mean, I think you might care because of the downstream effects of a potential fee award. Is that
Yes, Your
right?
Honor, that is
But
correct.
that fee award does not exist right now. And this might be a totally irrelevant point. The court could very well say, which is not uncommon in anti-SLAPP cases. Given the context of this whole litigation, this additional charge outside the statute of limitations didn't add any fees to this litigation, and so I'm not going to award any fees. So why wouldn't it be premature to address what strikes me as, this claim is not in the case. That's according to the trial court's ruling. You don't want this claim in the case because you say you never made it. So it seems to me you're totally simpatico with the trial court's ruling as it exists right now.
Your Honor, unfortunately, that's not quite the case, or at least not how we interpreted the trial court's ruling. If Your Honor's interpreted differently, frankly, that interpretation that you've just expressed, we would agree with should be how it is. But we interpret Judge Shadler's order as dismissing the Escala Cafe under the anti-SLAPP statute to dismiss, finding that there was such a claim and dismissing it on that grounds. You're right, Your Honor, that the problem there is the downstream effect of attorney's fees. We've already seen that derail this case, including putting an issue in front of you.
No,
The motion for
I think
security
my
is-
question is, do you think that issue is ripe for review when at the moment it is not adverse to Mr. Waldman? I mean, right now, it's a friendly ruling. It's friendly in the sense that, it is true that part of the ruling opens up a door that could later be a lead to an adverse ruling for you. Right now, the ruling is this is dismissed, parentheses under the Anti-SLAPP Act. That parenthetical might later create a judgment that is adverse to you, that you would have a right to appeal. They shouldn't have awarded fees. But I don't know why we care about this right now. I mean, there's nothing adverse to you yet.
Well, Your Honor, it is adverse to us already because Mr. Simler has sought a motion for security, including asking for over $100,000 in security with that. At the time, after Judge Sadler's ruling.
I mean, he hasn't succeeded on that.
No, you're right, Your Honor. He
So it's not
hasn't,
this was
but
a-
we've already been burdened by having to defend against it on those grounds. Immediately after.
That tends not to be a basis to find a ruling as adverse for appealability purposes. I mean, my question is, this is a jurisdictional requirement. That it be an adverse ruling, and the fact that, oftentimes non-final rulings, for instance, will lead to extra burdens on parties, but that doesn't make them final and appealable.
Fair enough, Your Honor. However, I will say that with respect to whether this is a final or appealable, it is final with respect to whether or not there was a time-barred claim. And to the extent that the Superior Court has concluded there was a 2017 time-barred claim, well, now we have a final ruling that it's done. If, there's with prejudice, there's any of that. Now, with respect to the other grounds of jurisdiction that we explain in our brief, you're here with a scenario where this court has determined that interlocutory appeals are appropriate for denials of anti-SLAPP motions to dismiss. So we have part of that. When a defendant files their anti-SLAPP motion to dismiss, you're going to get three outcomes, right? Either it's granted in full, it's denied in full, or it's a partial like this, partial grant, partial denial. Well, if it's denied or granted in full, that's immediately appealable, either as the final order because the case is gone or as the interlocutory appeal. Here, we're at a situation where it was granted in part, denied in part. The granted in part was appealed, or pardon me, the denied in part, the part adverse to Mr. Simler was appealed under their right for an interlocutory appeal. So, Your Honors, the court should exercise either under the collateral order rule or its pendant jurisdiction to hear this at the same time. Why kick the can down the road when you're already looking at the same complaint, having the parties in front of you? Why extend, in our case, an almost 7-year case and promise another 2 years when Mr. Waldman later has to challenge the fee award that Mr. Simler has already attempted to get, has already said he's going to be applying for, and has already sought security for? So this is an issue that is directly affecting the parties, and frankly, it would be wasting your resources if you make us come back here in 2 years instead of handling it all at once when there's already an appeal. Now, in the event that Mr. Simler was not making an interlocutory appeal, was just accepting the denial of his portion of the anti-SLAPP statute, I would agree. Perhaps Mr. Waldman should not be bringing his own interlocutory appeal, but we're not in that situation. And your honors certainly don't need to create a new rule allowing a defamation plaintiff to bring an interlocutory appeal of a partial grant. We just need you to exercise your pendant jurisdiction to save the court and the parties' resources that have already been extended far more than the statute ever envisioned. And that's well within the court's jurisdiction. Thank you, your honors.
Thank you very much. Thank you to both sides for your briefing and your arguments today. The case will be submitted and we are adjourned.